Lordship, my lord, item 29, my lord. 29.
Yes.
Item 29, what?
Yes.
But can it be listed after the vacation? I'm for the respondent 6, 7, 13, 14, and 16.
6, 7,
13, 14, and 16.
14, 15, 16.
Can it be listed after the vacation?
Okay. The petitioner side. Okay. Mr. D.K. Bhattacharya, Learned Counsel for the petitioner. You were for Corporation Department.
Respondent number 19 and 20.
1920. Mr. A. Somoa, Learned Counsel for the respondent number 6, 7, 13, 14, and 16. And Mr. B. Raskwa, Learned Counsel for the respondent number 19 and 20.
19 and 20.
Anybody else are
No.
present? Mr. Somoa has sought for listing of the case after the ensuing long vacation in July, on a date after the first of, as the prayer for such listing is not opposed by the Learned Counsel for the other sides, the prayer is accepted, list the case on. So it's
2707.
interim order. The interim order passed earlier shall continue till.
I will bless.
Lordship, may I make one prayer, Your Lordship?
Yes.
I have filed one IA, Your Lordship, in item 29, IA 15072026. There is certain defect in the numbering, Your Lordship. I may be allowed to withdraw and be liberty to refile it.
I to belage order pass koribo. Mr. B. Raskwa, Learned Counsel for the applicant, has submitted that as certain inadvertent errors have crept in the application, he wants to withdraw this application in order to file a fresh.
A fresh, Your Lordship. Item 29.
The prayer is allowed. Any objection?
No.
The Learned Counsel for the
1507.
Learned Counsel appearing for the opposite parties have submitted that, they have no objection to the prayer submitted by Mr. Raskwa. So accordingly, the instant application stands dismissed on withdrawal, with the liberty to file a fresh.
Lordship.
Item number 19, motion matter, some development taken place. So, matter may be adjourned for a week after vacation.
On the request of Mr. P.J. Soikia, Learned Counsel for the petitioner, the case be listed after a week on a date to be fixed by the office. It is submitted Mr. N. Das, Junior Government Advocate, Assam for the state respondent, and Mr. A. Raskwa, a Authorised revenue are present.
May I please? My lord, on additional affidavit has been filed today, my lord, to bring on record, my lord. May
In
I?
which case?
My lord, item 54, my lord.
54.
In 34, but I will be in reply filed today.
No, I have the same prayer with item number 33, Mala, call for the reports. Also, Mala, I also pray for listing of a motion matter on Wednesday, Mala.
But miscase for eviction matter, my lord. I filed one miscase on 26. Let it come day after tomorrow.
Lordship, motion matter for Thursday, Lordship.
Wednesday?
Lordship, another prayer is there, Lordship. I beg to mention item number 38, Lordship.
Yes, 38.
38, Lordship.
Yes.
In this case, we are required to file our affidavit in reply to the affidavit of opposition filed by the respondent authorities, Lordship.
Okay. Respondent means state respondent
Lordship,
or NHIDCL.
Lordship, state is also there, and SIDCL is also there, but state has filed the affidavit, Lordship.
Okay. Mr. P. Bordeaux, Learned Counsel has sought for and is granted. How much time?
Lordship, after vacation, Lordship.
Okay, 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the state respondents. List Ms. M. Borman, A. Potasai, revenue present. List the case accordingly.
Oblige, your Lordship.
Lordship, I beg to mention item number 60 of the supplementary list. I pray for some accommodation in this matter, Your Lordship. Learned Counsel is out of town conducting counsel.
60.
60, Your Lordship.
Your name, please.
A. Das.
On the request of Mr. A. Das, Learned Counsel for the petition, the case is adjourned for 1 week. It is submitted that consent has been taken from the Learned Counsel for the respondents to make the prayer.
In item number 45 and 46, I am take, praying, my lord, a short date, my lord. I have to take instruction from my client, my lord, on Thursday if possible, my lord.
Hmm?
On Thursday, my lord, if possible. 45 and 46.
Let us see what happens. 45 order, whether
Yes, sir.
service report is complete.
My lord, not complete.
Okay, let us see.
I beg to mention item number 43 on this. Question may kindly adjourn the matter.
43.
Yes.
Yes, what do you want?
Adjournment for the day.
Okay, on the request of Mr.
TK that was.
PK Das Learning Council for the petitioner, the case is passed over for the day. It is submitted consent.
Lordship, it permitted me to file a short note, Lordship, in those remission matters that are listed.
I'll give it to you.
May I please, your lordship? I beg to mention item number 42 of the daily list, your lordship. In this matter, we are yet to file an affidavit, your lordship. So 3 weeks' time may be granted.
Miss
P. Upadhyay, your lordship.
P. Upadhyay Learning Council on behalf of
Mr. S.C. Kyala,
S.C. Kyle, Senior Counsel and Senior Special Counsel CGST has made has sought for and is granted 3 weeks time to file counter affidavit on behalf of the respondent GST authorities. First of it is submitted that anybody
For
present,
petitioner, lordship.
Miss
M. Day.
M. Day Learned Counsel for the petitioner who is present, I have submitted that she has no objection to prayer. And praise the Lord, list the case accordingly after 3 weeks on a date to fix by the office. Any interim order?
Yes,
The
lordship.
interim order passed either shall continue till the next date of list.
Lordship. Lordship, I also beg to mention for a listing of a writ petition for motion.
Lordship, item number 48, Lordship.
Wednesday, huh? Wednesday going.
Lordship, item number 48, I have seen the office notice. Notice was served, but still respondent number 5 is not
Let,
received. I may be allowed to fresh notice, issue fresh notice.
we'll examine the file thereafter. Next.
Lordship, with respect to item number 27, Lordship, Lordship, we are required to file our affidavit in reply. Lordship, Lordship may grant us some time, Lordship.
Affidavit in reply.
Lordship.
Okay, Mr.
B. Sharma.
P. Sharma, Learned Counsel for the petitioner has sought for and is granted. How much time?
Lordship, after the vacation, it will be
Okay.
listed.
4 weeks time to file an affidavit in reply. You have informed the other side.
We will inform the Council for the State Respondents, the State of Assam. We will inform the Union of India
Consent
Council.
executive of leaves the case accordingly after 4 weeks on a date to be fixed by the office.
All right, Lordship.
May I please, Lordship, listing on motion matter, Lordship.
What subject?
Lordship, land matter, Lordship.
Land matter means what kind of land matter? What kind of land matter? No idea.
No.
Come back again tomorrow.
Lordship, I beg to mention for listing of a writ petition matter for orders, Lordship, after vacation.
After.
May I please, Lordship? I beg to mention for item number 59, Lordship, the daily list, Lordship, on the order column, Lordship.
Yes.
The respondent number 5 has filed the affidavit in opposition to the Lordship. We would like to file the reply, Lordship. Can the matter be listed after granting a 3 weeks time, and can the matter be listed
Your
after the
good name,
vacation?
please.
Pilam.
Learned
behalf of
Counsel appearing for a petition has paid for and is granted 3 weeks time to file an affidavit in reply to the affidavit in opposition filed by the respondent number 5.
Yes, Lordship.
Leaves the case, counsel leaves the case after 3 weeks on a date to be fixed by the office.
Give you a blast.
May it please, your lordship. I beg to mention item number 32, prayer for adjournment. We have taken consent from the other side.
Okay, Mr.
A. Deka on behalf of S.H. Sigdar.
has made a prayer for adjournment of the case for 2 weeks. It is submitted, consent liquidable, leave the case accordingly after 2 weeks on a date to be fixed by the office.
Oh, nice.
Daily list for withdrawal, item 1.
This matter is otherwise for compensation of land which has been acquired for a dike. But now, Lordship, it appears, Lordship, the family members of the petitioner are not petitioners here, and there has been further some developments. Therefore, my client has instructed me that we withdraw the case and we file it afresh with the new materials on record.
Okay, Mr. R.K. the actuary learned counsel for the learned senior counsel appearing for the petitioner has submitted that in view of subsequent developments during the pendency of the writ petition. And the writ petition is allowed to be, petition be allowed to be withdrawn with the liberty to file a press
Lordship.
with the, full particulars. Miss
P. Saye on behalf of RM Das.
P.
P. Saye on behalf of RM Das, Water Resource Department.
Water Resource Department for the respondent number. Two. Two,
2 and 5, Lordship.
2 and 5, Miss A. Bormon, M. Bormon. 1, 3, 6, aforesaid. 4 are present. In view of the above submission made by Mr. R. K. Dev Choudhury, Senior Counsel appearing for the petition, the writ petition is dismissed on withdrawal with the liberty as grateful.
Also, my lordship.
Hard,
But ground is he's not an Indian national. So therefore, there is a direct violation of Article 177.
no, RPF for Constitution Fund.
173A.
Mr. K. N. Chaudhary, Learned Senior Counsel, state by Mr. T. Deori, Learned Counsel for the petitioner. Full stop. The petitioner has averred that he submitted nomination papers and contested the election to the Assam Legislative Assembly from the constituency, Legislative Assembly constituency, 126 Ramkrishna Nagar, within bracket SC, LAC, wherein the respondent also submitted his nomination paper and contested the election. First of the election, the general election to the Assam Legislative Assembly 2026 was held on 9/4/2026, and thereafter, the results were declared, wherein the respondent was declared elected from the seat 126 Ramkrishna Nagar SC LAC. Full stop. Para. This election petition is filed by the petitioner under section 80, read with section 80A, section 81, and other related provisions of the Representation of People Act 1951. Full stop. The main ground on which the election petition is filed is that the respondent lacked a qualification prescribed in Article 173 within bracket small a of the Constitution of India, and therefore, his election is to be declared void under section 100 within bracket 1 within bracket small a of the Representation of the People Act 1951. So this is the ground.
Yes.
Okay. Notice is required to be issued. First of let notice be issued. The notice is made returnable on so and so.
3rd August 0308.
Any special mode? I'm not accustomed.
Speed post, my lord.
Okay. The notice, the petitioner is to take steps for service of notice upon the respondent number. Respondent in the prescribed mode, including speed post within 3 working days from today.
My lord. Deep cut.
3.
Item number 3.
Also, we have filed this contempt petition being agreed.
Heard Mr. N. Gautam, learned counsel for the petitioner. Post of this contempt petition is preferred under Section 12 of the Contempt of Courts Act 1971, read with Article 215 of the Constitution of India, alleging deliberate violation of the direction made in an order dated 23/6/2025, passed in a writ petition WPC number 4997/2024. It is averred that the order dated 23/6/2025 was duly brought to the notice of the respondent, and in spite of service of notice, no discernible action has been taken by the respondent till date. Issue notice returnable in 4 weeks. Steps by speed post within 2 working days from today.
I don't propose to double your lordship with the.
Yes.
Point is very simple and only one. And it is now fortunately covered by a Supreme Court judgment recently given. You know, the import-export policies keep changing. At the time when we imported this printing machine and the accessories, the prevailing policy was that you will get a concession, but there will be a export obligation on your part, namely that you have to give 5 times the value of the purchase within a period of 8 years. We failed. Admittedly, we failed there. Your lordships know our industrial policy of the central government itself for the Northeast. It is an acknowledged fact that it is a very limited area where they are operating, and they have been given a lot of concession in that regard. So it was impossible for us to go because it's a printing press. 2 paper mills have been closed after we got this benefit. But the question is now, if we fail, they are threatening us with penalty under Section 11. Now, for a moment, if your lordships will kindly have a look at Section 11. That's the short point, my lord.
Yes.
No export or import shall be made by any person except in accordance with the provisions of this Act, the rules and orders made thereunder, and the foreign trade policy for the time being in force. Now, subsection 2. Where any person makes or abets or attempts to make any export or import in contravention of any provision of this Act, or any rules or orders made thereunder, or the foreign trade policy, he shall be liable to a penalty of not less than 10,000 rupees and not more than 5 times the value of the goods of or services or technology in respect of which any contravention is made or attempted to made, whichever is more. So the penalty is imposed subject to these conditions being fulfilled. The question is, my lord, suppose the export obligation which was imposed, we fail. Is it open for them to exercise the power of Section 11? That was the issue before the Supreme Court. And the Supreme Court said, relying on language of section 11, that it is not covered. I'll just hand over to your Lordship. Identical situation. There was also a para 3.
Actually,
Para 3, just factually also the same sort of situation. A few factual aspects will have to be set out. Karnataka so-and-so obtain an export promotion capital goods license for short the license, which enable it to import certain capital equipment at a concessional rate of customs duty. Under the license, the Biotics was permitted to import capital goods worth so-and-so, subject to the condition that the appellant exporting the finished goods with worth so much and earning an equivalent amount in a freely convertible foreign currency within 5 years from the date of the license. Karnataka Biotics imported goods as permitted under the license. However, now if your lordships para 5, on 3/6/2003, BIFR, that is the board, Board for Industrial Finance and Reconstruction, for short BIFR, which your lordships will see at page 4, paragraph 4. BIFR sanctioned Karnataka Biotics Rehabilitation Scheme under Section 18 of SICA. On 16/7/2004, the third respondent passed an order in original imposing a penalty of rupees so-and-so on Karnataka Biotics for non-fulfillment of export obligation under the license. Because the concession given was similar to ours, and appeal preferred before the appellate authority against the said demand was dismissed and a review filed before the central government was rejected. Our representation before central government is pending and they have not taken any decision to penalize us. Now, the local office here is threatening us that we will now impose a penalty. Now, if your lordships kindly turn to para 8, my lord. It starts.
yes.
And if your lordships turn over the page, just before paragraph 9 starts, my lord. The learned senior counsel, he invited our attention to the order in original passed by third respondents imposing a penalty of 23,38,000 and odd under section 11 of the Act, FT Act, the same Act, my lord. The learned senior counsel would submit that non-fulfillment of export obligation under the license is not a ground under section 11(2) of the FT Act to impose a penalty. He submitted that the order imposing a penalty under section 11(2) of the IT Act was completely illegal. The same issue as we are raising, my lord. Then the 9, my lord, and the 10 considerations. Now, if your lordships kindly turn over to para 14.
Yes.
We have perused the order in original passed by the third respondent, which levied the imposed penalty of so much. The order in original records that Karnataka Biotics did not comply with the export obligation under the license granted under the FT Act. Therefore, the penalty was imposed specifically under section 11(2). Thus, the waiver granted under the rehabilitation scheme is of no assistance to the appellant as it was only of the customs duty. Section 11 then, my lord, is quoted. Subsection 2 applies when any import or export is made in contravention of any provisions of the FT Act rules and orders made thereunder, or the foreign trade policy. And
Yes, I have understood. Yes,
there are 16.
I have read.
Your lordship has read.
First of all, lordship, this reputation is non-maintainable at this stage, lordship. It's a premature reputation, lordship.
But there is threatened action.
No action was taken till today. It's a show cause notice, lordship. Alternative remedies also there, lordship. That today, till today, lordship, no action was taken, lordship. It's a no panels.
No, if the basis of the show cause is, if the basis of the show cause,
Lordship.
suppose
Lordship,
they have imported the machinery
Lordship,
under a
lordship,
certain
lordship,
scheme with
Lordship,
certain benefit,
lordship.
laced with the condition that they have to meet an export obligation.
Lordship,
There was zero
lordship,
export,
lordship,
right? After getting the benefit,
lordship,
there was zero export.
lordship.
So where is the penalty provision for initiation of certain action?
So they have to reply the notice, lordship. So they have to reply the notice, lordship. They have to reply the notice.
No, when the
lordship.
show
Till-
cause there are,
till today,
it is not that,
lordship.
that just for every show cause notice, one has to make a reply.
Lordship, probably they have today, lordship, we cannot discuss.
Whether they have been replying or not.
They have not replied, lordship. The notice which was, they have put to silence, lordship.
This whole bulk
594 onwards, lordship. 594 onwards, lordship.
What you are threatening, what kind of show cause reply you are asking for?
Lordship, 595, lordship.
95.
595.
Let me see.
595, lordship.
595.
How they have agreed, lordship.
538.
Submission
Five?
documents, 595, lordship.
Let me go to 595.
Lordship,
595.
lordship. Annexure 71, lordship.
What action is contemplated
Subject
under
is-
this?
Subject is submission to document, lordship.
No, what action is contemplated by this?
Lordship, that action,
What action?
they have not discarded, they have to submit the documents, lordship. If they properly submit the documents and reply, lordship, no action will be taken, lordship. Till
Was
today,
there nothing earlier?
lordship.
Was there nothing earlier
Nothing,
to
nothing.
this letter?
Nothing, lordship.
Huh? This is the only one.
Series is there, lordship. Reminder is there. Next to next page is all the reminders.
Earlier?
Earlier also there, lordship. They have to reply, lordship. No punitive action was taken till today, lordship. Nothing was done, lordship. They have to submit the particular documents, lordship. How they have agreed, lordship?
Was earlier anything was issued, or this is the first one?
We have submitted representations not only before this office, but the main, the authority, about 14 or 15, which we have annexed below. That's why it has become bulky. So the short question is it open for them to invoke 11(2) in a case of this description? And it is an admitted legal position, my lord. If a so cause notice is issued, which my lord, is entirely not fulfilling the conditions precedent, and then my lord, it lies, starting from Calcutta discount, this has been the position, your lordships know.
Here, lordship, only indicated there. They have to submit the documents within the 10 days period, lordship. They have to submit it, lordship.
No, we
They have to submit it, lordship.
innumerable times.
Whether any final order was passed, till today, no final order was passed, lordship. No penalty was imposed under section 11, lordship. The judgment which was relied by my seniors are, lordship. That is not totally not applicable here, lordship. In that particular cases, lordship, the penalty was imposed. Against the penalty, they have preferred under appeal under section 15 and review under section 16, lordship. Nothing was there, lordship.
No.
If any extra-
Why this is required to be gone through the long route?
Lordship.
Why it is required to be just because you are state
That is-
or
that is
union?
not
No,
the
no,
issue.
that is not
That
the
is not
only
the
issue.
lordship. That is not the issue.
No,
They
just
have-
because they will file the reply.
that
No,
is
that
not
is
the-
also not the,
That
cannot
is
be
not
the
the
same
issue.
issue.
Here, lordship, they have directed to submit certain documents, lordship. Nothing else, lordship. They have to submit certain documents, lordship. Till today, nothing was done, lordship. No action was taken from the authority, lordship. If action was taken, then statutory provision is there, section 15 lordship. And then section 16 is there lordship. The Supreme Court judgment which was relied by my senior sir lordship, all the remedies they have availed lordship. After they approach the writ court lordship.
Yes.
My lord, may kindly peruse section 15 and section 16 lordship. And the judgment which was relied by my senior sir lordship. After complying the statutory prescription prescribed by the statute lordship, they have preferred the writ petition lordship. Here that stage is yet to come.
Heard, Mr. What other action is, can be taken under the Foreign Trade Act? What more other actions are taken, can be taken? Mr. Gugoi,
Lordship, section
what
11 lordship.
other actions can be taken under this act
Section
other than 11?
lordship. Here lordship, they have not indicated.
Other than
lordship.
11?
Lordship,
No,
lordship,
you take me to the Foreign Trade Act.
Lordship. 11 lordship, 11.
Only 11?
11 lordship.
Heard, Mr. P.K. Goswami, Learned Senior Counsel.
Even lordship, section 9 also issue of suspension of the lordship, cancellation of license lordship. Section 9, 8 and 9 lordship. 8, 9 and lordship 11.
Those periods have already gone now.
8, 9 and 11 lordship. No action was taken till today lordship. They have just asked to produce certain documents lordship.
Mr. State by Mr. A. Gautam, Learned Counsel for the petitioner. Mr. K. Gogoi, Learned Central Government Counsel. For
1 to 7 and 9, except 8 lordship.
1 to 7 and 9 and 10. Who is for?
8 is for custom lordship.
There is Custom Council. Okay. The petitioner. In order to petition number 1. In order to is a private limited company. The petition number 1 is a private limited company wherein the petition number 2 is one of the directors and he represents the petition number 1 company in the present proceeding. First of para. The petitioner company, in order to enhance its printing capability, imported a machine, Heidelberg Speedmaster, para 2, SM 74-4H SE 4 color sheet fed offset press, along with other associated accessories under availing the benefit of duty exemption scheme under Chapter 5 of the Export-Import Policy prevailing during the period from 2002 to 2007. Full stop. The Respondent Union of India, in exercise of the powers under Section 5 of the Foreign Trade within bracket Development and Regulation bracket close Act 1992, Foreign Trade Export Sort, notified the export and import policy for the period 2002 to 2007, which came into effect from 1/4/2002. Post of. The policy allowed import of new capital goods at 5% customs duty, subject to an export obligation equivalent to 8 times of cost, insurance and freight CIF value of capital goods to be fulfilled over a period of 8 years, reckoned from the date of issuance of license. Post of. Subsequently, the petitioner company also imported something more.
Yes, the full license.
Which paragraph? Which paragraph?
One is for the between. Yeah.
Paragraph
10 at page 20.
10.
Between 148.
Another machine, top setter P-74 with print ready system and a high-speed cutter. Post of. The CIF value of the first imported machine was rupees 3 crore 5,28,830, and the duty saved was 1 crore 40,860, and the export obligation was 8 crore 35,26,880. On the other hand, the CIF value of the second imported machine was 1 crore 8,74,118. The duty saved was 38,46,794, and the export obligation was 3 crore 7,74,352. Post of. It is an admitted position that under the aforesaid 2 licenses, the total saved amount was 1 crore 42,87,654, and during the subsequent period, the petitioner company failed to meet the export obligation of rupees 8 crore 35,26,880 and rupees 3 crore 7,74,352. Para. As there is a provision for exemption.
Yes.
Which paragraph?
Clause 2.5 at page 95.
Or is a statement in the writ petition? Okay, as there is a
19.
Page?
And it is quoted 19.
as there is a provision for exemption in clause 2.5 of the export import within bracket exim policy. Wherein the export promotion capital goods scheme was floated, the petitioner, in view of its failure to meet the export obligation, submitted application for exemption from meeting the export obligation. Post para. In which year? From
That's from 2011 to 2016.
During the period 2011 to 2016, before the respondent number,
That's from respondent to respondent number 3
respondent number 3, respondent number 3
and the connected ministry.
and the
Connected ministry. Commerce and investment.
and the concerned ministry in the government of India. Post of para. And the present writ petition is referred to a sale actions on the part of the respondent
Respondent number 5, 6, and 7.
or respondent of 5 to 7 authorities in view of their contemplated penal action under the provisions of the Foreign Trade Act. Post up. The petitioner has submitted that despite pendency of the exemption prayer before the concerned ministry, the respondent number 5 to 7 have proceeded to issue notices which are in the form of so-called notices, whereby the petitioner have been asked to submit documents on the premise that the petitioner company has failed to fulfill the export obligations under against the exemption availed by it. Full stop. A reference has been one of such notices is 24 is dated 22/4/2026. As a final reminder to submit the documents regarding fulfillment of export obligations, or else necessary action will be initiated against the petitioner company under the Foreign Trade Act. Post up. Para. It is the contention of the landed senior counsel appearing for the petitioner that the show-cause notice, the show-cause notice is issued by the respondent authorities, including the show-cause notice dated 22. Notices issued by the respondent authorities from time to time, including the notice dated 22/4/2026, suffer from jurisdictional error in the sense that in that failure to meet export obligation under the exim policy and the scheme framed thereunder will not invite an action under section 11(2) of the Foreign Trade Act, first of, in support of his submissions, he has submitted that the matter, the issue is also covered by our decision of the Supreme Court in Embio Limited versus Director General of Foreign Trade and Others 2024, 6 SCC 633 post of para in response, Mr. Gogoi, learned Central Government Council appearing for the aforementioned respondent authorities has vehemently opposed the contention of the land contention advanced on behalf of the petitioner company by submitting that the notice has only asked for the documents regarding meeting of export obligations against the benefit already availed by the petitioner. First of we have submitted that it is an admitted position that the petitioner company has failed to meet the export obligations against the against the import of two machines by availing the duty. First of
One machine and the second is accessories.
on two occasions. First of the matter would require consideration.
So I also raised the question of maintainability of the repetition. As because statutory prescription is there, 15 and 16 also.
Here, Mr. Gogoi has submitted that the petitioner has alternative remedy of appeal and review under section 15 and section 16 of the Foreign Trade Act. First of para, the issue notice returnable on so and so, as Mr. Gogoi and his Central Government Council has appeared and accepted notice on behalf of the so and so. Issuance of formal notice to the said respondents is dispensed with. The learned counsel appearing for the petitioner shall furnish requisite number of extra copies of the petition along with annexer to Mr. Gogoi within 2 working days from today. The counsel for the petitioner shall also serve a copy of the petition along with annexer to the learned standing council customs within 2 working days from today. First of para, section in it is settled. It is a settled provision that a show cause notice does not ordinarily give rise to a cause of action for preferring a writ petition under Article 226 of the Constitution of India. First of, but in the event in any notice or in the form of show cause notice suffers from error of jurisdiction error, comma, a writ petition against such notice is, it cannot be said that a writ petition against such notice is not entertainable. First of, in the notice dated 22/04/2026, comma, the respondent authorities has asked the documents regarding not meeting regarding the failure of the on the part of the petitioner company to meet the export obligation with the contemplated action under for contemplated action under the Foreign Trade Act. First of para, it admittedly, comma, the petition company failed to meet the export obligation Full stop. In Embryo Limited Supra, comma, Section 11 of the Foreign Trade Act has been considered, more particularly subsection 2 thereof. Full stop. In that context, comma, the Honorable Supreme Court has held that in the event there is no allegation of attempting to make an export or import, the action would not be covered by section 11(2) of the Foreign Trade Act. Also, only in an event of an export or import in contravention of the export and import policy, the provision of section 11(2) of the Foreign Trade Act would be operational. And since the same is a penal provision, it is to be strictly construed. Full stop. Other than first of having considered the provision of section 11(2) of the Foreign Trade Act and the interpretation given in Embryo Limited, comma, I find this court finds primacy force in the submission advanced on behalf of the learned, advanced on behalf of the petitioner. In that view of the matter, in such view of the matter, it is ordered in the interim that there shall not be any coercive action against the petitioner company. And considering the fact that there is no final decision on the exemption application till date, comma, it is been ordered in the interim that there shall not be any coercive against the petitioner in terms of the notices issued by the respondent authorities regarding failure to meet export obligation with the contemplated action under the Foreign Trade Act, including the notice dated 22/4/2026 till the returnable letter.
31st July. 3107.
Deeply obliged.
May please, your lordship. Lordship, this was a requisition matter. On the last occasion, your lordship has directed the respondents to furnish the reports regarding the areas.
I have secured the record. The rules say, rule 3 of the requisition rules of 1964. It says, my lord, that if I may read it, an order of requisition under section 3(1) shall be Form B as far as may be with such modification, if any, as may be necessary. So the form itself is the order as per the rules. And this practice has been followed since long, my lord. So far as my lord, the 1964 Act is
Form B is there,
Yes.
simple Form B is there.
Yes,
First you see section 3.
yes,
Section 3. Don't go by the proviso.
yes, my lord, provided we are not going.
Hmm.
If I may read it, my lord.
Yes.
Power to requisition, section 3. If in the opinion of the state government or any person authorized in this behalf by the state government, it is necessary so to do for maintaining supplies and services essential to the life of the community, or for providing proper facilities for accommodation, transport, communication, irrigation, flood control, and anti-erosion measures, including embankment and drainage, or for providing land individually or in groups to landless, flood-affected or displaced persons, or to a society registered under the Cooperative Societies Act, or a company incorporated under the Companies Act, formed for benefit and rehabilitation of landless, flood-affected or displaced persons, or to provide land for the purpose of construction of border fencing and allied work, including border works, roads.
Just a minute, this document does not have mean to the auction.
These were inserted by 1985 amendment, madam. Or to provide land for construction. This was inserted by 1985 amendment.
Yes. For the purpose of construction of border fencing.
Yes, my lord.
Yes.
For fencing, including border roads and checkposts connected therewith, along with Bangladesh border, the state government or the person so authorized, as the case may be, may by order in writing requisition any land, and may make such further order as appear to it or to him to be necessary or expedient in connection with the requisitioning. Then subsection 2, my lord, an order under subsection 1 shall be served in the prescribed manner on the owner of the land, and where the order relates to land in occupation of a tenant, also on such tenant. Now,
Subsection 3.
yes, where the order for requisition is made by authority other than the state government, any person interested in the land within 30 days from the date of service of the order may appeal to the state government, and the decision of the government in such appeal shall be.
So here is a delegated authority.
Yes. Now, my lord, now the district commissioner of each district has been empowered under the provisions of section 3, as well as, my lord, up till the exercise to be carried out till section 6, my lord.
So there is a provision for appeal.
Yes, there is a provision for appeal.
If the order is made by delegated authority, empowered authority,
Absolutely.
other than the state government, right?
Yes,
Now let us see the rules now.
yes, my lord. Lordship comes to the rules, my lord. First of all, Lordship may be pleased to see, my lord, Rule 3. May I read it, my lord?
Yes.
Rule 3. Manner of submission of representation by interested person when land is necessary to be requisitioned for landless or displaced person. Now here
It is connected. Let us see it here.
Yes,
It is for
drainage.
construction of drainage,
Yes.
not landless.
No.
So rule 3 is not attractive.
Rule 3, meaning thereby, my lord, Form A is not applicable here. The authority will have to here in the present case, authority have, my lord, initiated the exercises by applying Rule 4, by issuing, my lord, Form B. Therefore, Rule 4 says, my lord, if I may read it kindly, my lord, an order for requisition under section 3(1) shall be Form B as far as may be, with such modification, if any, as may be necessary. Then, my lord, Rule 5, an order under section 4(1) of the Act shall be in Form C. This is connected with taking over possession, my lord, where the surrender of delivery of possession is to be made to any person other than the collector the letter shall issue on order authorizing the person before an order for surrender or delivery of possession is
Where is the
issued.
service?
Yes,
In the prescribed manner. Because the rule section 4 says
yes,
subsection 2, section 3, subsection 2 shall be served in a prescribed manner.
yes.
Where is that service?
Now, this has been served, my lord.
Lordship, Rule 11, it has been mentioned, the prescribed manner.
Prescribed manner. Okay.
Manner of service of order.
Okay. Prescribed manner. Yes.
Now, my lord, I'm told, my lord, that this, now, lordship may be pleased to see, my lord, Form C and Form
No, no,
D.
service.
Service, my lord, I am told, my lord, that it has been served on all the individual through, my lord, the circle officer. That service report is not before us today. That service report is not, but
Because
it has been
in
served.
between,
Yes,
after order 3,
yes.
order passed under section 3,
Yes.
right? That they have a provision for appeal.
There is a
If the
provision.
empowered authority issues,
Yes.
so it is a must
Yes.
that the service
It has to
must be
there.
effected in the prescribed manner, in no other manner.
Absolutely.
Right.
Absolutely.
I think there is no evidence as regards registered post,
Yes.
right? So let us rule out registered post. Now, delivery or tendering to that person,
Yes.
right? Or otherwise affixing in presence of 2 witnesses.
Yes.
Whether that opportunity of preferring an appeal can be availed or not, because law is settled. When a mode is prescribed in the
It
statute
has to be done.
to be done in a particular manner, that must be done in that particular manner, in no other manner.
Absolutely.
Right?
Absolutely.
So show us the evidence.
Yes.
Because there is an opportunity loss of filing an appeal.
Yes. Yes. Yes.
That's all.
Because
That is what I asked for.
absolutely, because the lordship order says last time.
No, because
Some order
I
is
think
yeah.
Pujari, you
Yes,
will
yes,
be
yes.
knowing everything.
Yes, yes,
So what was the intention of the court?
Because I have secured the original file, but it doesn't contain, my lord. I apologize, my lord. It doesn't contain, my lord, the service report, because I am told, my lord. But
Because I am not into the requisition.
Yes, yes.
You may need it for public purpose. But at the same time, something related to Article 300A is
Yes.
involved.
Absolutely.
Right.
Absolutely.
As an eminent domain, you have the everything, right, for public purpose. Question is about following the
Absolutely.
prescribed mode. I am nothing against the petitioner, but question is rule of law.
Absolutely. Absolutely.
That's all.
So under that circumstances, your
Tomorrow.
lordship
Otherwise, I'll
tomorrow.
state.
Yes, tomorrow. Yes.
Or otherwise, I'll state. Show us the evidence. We are running short of time. You may need it for public purpose.
Yes, tomorrow. Yes.
Okay, Mr. Deka, petitioner, Arbor Project, Standing Council, Revenue and Disaster Management for the respondent number 1. Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 2 and 3. And Miss PSCA Learned Council on behalf of Mr. R.M. Das, Learned Standing Council Water Resources Department for the respondent number 2, full stop. The Learned Council for the parties have taken that vote. Have. In the course of submissions have made reference to section 4, section 3 of the Assam Land bracket Requisition and Acquisition Act, Requisition and Acquisition bracket close Act 1964 and Rule 4 and Rule 11 of the Assam Land within bracket Requisition and Acquisition bracket close Rules 1964. Full stop. Para. Mr. Gaur Pujari, Standing Council, Revenue Department has sought time till tomorrow to obtain the relevant records pertaining to compliance of Rule 11 of the Assam Land within bracket Requisition and Acquisition bracket Rules 1964. Insofar as the petitioners herein are concerned. We are not.
My lord.
We are not.
In fact, my lord, I apologize. I ought to have secured the entire record.
No, it's
That was
okay.
messed
It's
up, my lord.
okay. It is not easy also. But these 7 petitioners, right? Those who have not come, we are not concerned with.
My lord. Lordship has fixed tomorrow, my lord.
Huh?
I'm so obliged.
I do not want to keep it on the last.
In fact, my lord, we are devoid of an extra copy of the writ petition. I'll be seeking a copy of the writ petition.
Mr. Daga, give a copy to
And
a
some
copy
various
of the
situation
petition is to be furnished to Mr. Barpujari during the course of the day by Mr. Dekal, Learned Counsel for the petition.
I'm so deeply obliged.
Please take us tomorrow.
6.
Section 14.
Lordship, I will take instructions, Lordship, why this, the deployment was withdrawn, Lordship.
And on the date,
Police was there, Lordship, but it was withdrawn.
movement was taken up on that day, but from the mid of the movement, it has been.
Get an instruction.
Lordship.
Heard, Mr. Well, you should notice, otherwise, since all are, what these are required, 4 and 5, Mr.
They are the performer, Lordship,
Performer respondents.
borrower, your Lordship.
We are not, they will again create more problem.
Lordship.
Their appearance will create more problem. It is regarding action on the part of the respondent number
Yes,
2 and 3.
They are only agreed with the, that withdrawal of
Order,
the.
order under 14.
Lordship.
Laws are settled. Whatever is there, you should not have withdrawn. Heard Mr. M. Sharma, Learned Counsel for the petitioner, and Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number
1, 2, and 3.
3, full stop. In this petition, the petitioner bank has projected that despite an order dated 12/12/2025 under section 14 of the, what is that full form?
Surface, yes.
Surface লিখে দিব। There is non-compliance. There was non-compliance of the said direction during the subsequent period for taking over physical possession of a secured asset. Mr. Sharma, Learned Additional Senior Government Advocate appearing for the respondent number 1, 2, and 3 has submitted that he needs some time to obtain the instruction as regards the region for withdrawal of the assistance on the date. On which date?
On 30th January 2026.
30/01/2026, the date schedule for taking over physical possession of the secured asset as in terms of section 14 of the Service Act.
It is 29/1/20.
29(1). Having regard, let the notice be issued to the respondent number 1, 2, and 3 at this stage. The notice to respondent number 4 and 5 is not issued at this stage in view of the issue raised in this writ petition. The notice is made returnable on so and so, as Mr. Sharma has appeared and accepted notice on behalf of the respondent number 1, 2, and 3. No formal notice is necessary. However, the Learned Counsel for the petitioner shall furnish requisite number of extra copies of the writ petition annexed to Mr. Sharma during the course of the day.
Yes, sir.
The respondents are to ensure that their stand is to be brought in on affidavit before the returnable date.
By open affidavit.
Yes.
Lordship.
2707. Item 7.
Yes.
May I please, my lord? So, my lord, actually, we are apprehending, my lord, eviction pursuant to, my lord, notices dated, so we have submitted our replies. My lord may be pleased to find is that, my lord, notices start from page 68, my lord, lecture 9. My lord, similar, exactly similar, some of the petitioner had approached, my lord, before this honorable court also, and in that case also, my lord, notice had been issued. And some protection had been provided, my lord, that without the due, following the due procedure of law, the petitioner should.
Already division bench is there. Why you are repeating the same thing? Salakuddin is already there.
My lord, my lord.
Supreme Court decisions are there, but you are coming with what interest?
The forum is, my lord, I have to, my lord.
Yes.
Lordship, that page 84.
This is repetition of Salakuddin.
My lord, repetition, but the authorities are also, my lord, issuing the notices in such a manner, my lord, that we have to approach before my lord.
Yeah, well, I say page 86, Senior Counsel for the
When
petition.
notices are issued, Lordship, it means they are given the opportunity of hearing. That is why the notices are
My
issued.
lord, we have participated, my lord.
Thereafter, nothing remains, Lordship. Page 83 and 84, that is the order, Lordship.
For the petition assisted by Mr. I. Hussain. Mr. H. Sharma, Learned Additional Senior Government Advocate for the respondent number 1, 3,
1, 3, 4, and
4,
5.
and 5, and Mr. Modular Learned Standing Counsel Revenue Department for the respondent number
Revenue.
2. Page 83, Savo, 67 or height 21.
Not inclined to pass any blanket order of stay. However, it is provided that
21,
Following
the
due
notice
procedure.
returnable on
3107.
3107. Baki 83, 84, same.
Text.
Hmm?
For the interim protection.
Same order.
My lord.
Same order.
My lord, my lord, may I pray for the tagging along with that similar matter?
No, I don't know when it is. Get the tagging order on the next day.
extra copies.
Obliged, my lord.
Already.
My lord, my lord.
Same.
Lordship.
Is it not providing for that order?
In that order, most probably it is not there. That is why.
Huh?
We have already submitted.
It is there.
Lordship.
It is there.
Lordship.
I'm not repeating it.
Lordship.
I'm saving some energy.
Lordship.
Obliged, my lord.
Met me, Lordship.
Where is the respondent?
Item 8.
Let them come.
Item number 9.
That is all. Sir, here, my lord, the petitioner is a private employee. And her, he has a salary account in the London Bank, my lord. Kotak Mahindra Bank, account number 2. and her salary account is freezed by the Kotak Mahindra Bank in connection with the cyber fraud case.
Heard, Mr.
Lordship, I have a submission, Lordship. It is to be dismissed, Lordship. Your Lordship may kindly come to page 4.
Page.
Page 4. This says, State of Assam to be represented by the Principal Secretary, the Government of Assam School Education Department. Why this Education Department?
No, no, no.
It was corrected, my lord. I have corrected that.
That corrected copy is not before me.
Oh,
I will,
Lordship.
no, it is not there.
it was my mistake.
Then Lordship, mainly the bank, as because
Bank.
there is a clearance from the cyber crime.
Heard. Then you are for response number 3.
3.
Heard, Mr.
NP Dora.
NP Dora.
Lordship, may.
Learned counsel for the petitioner,
Yes, Lordship. Please.
Mr. A. Sharma, learned additional senior government advocate for the response number 3. Post of the petitioner maintains. It is stated that the petitioner maintains a bank account number 32451 at Tornagar branch of the respondent Kotak Mahindra Bank Limited, within bracket response number 2. Post of. The petitioner stated that in the state bank account, comma, her salary gets deposited. Post of. However, in view of a suspicious transaction of rupees 1,000 registered in National Cybercrime Reporting Portal, NCRP, provides acknowledgement number para 3. And UPI transaction number ID, so and so, para 3, layer 2. The account has been kept debit freezed by the respondent bank authority. It is stated that the complaint regarding suspicious transaction of rupees 1,000 has been generated from the respondent number 1 postal issue notice returnable on so and so as Mr. Sharma for the no formal notice, extra copy to working this. The petitioner shall take steps for service of notice upon the respond number 1 and 2 by speed post within 2 working days from today. Upon appearance, the respond number 2 shall at the time of appearance, command the respond number 2 is to obtain is to place instruction whether apart from the suspicious transaction amounting to rupees 1,000, as alleged by the petitioner, there is any other suspicious transaction in the bank account of the petitioner.
Yes.
Item number 10.
May I please, my lordship? Entire bank account have been frozen blankly by the responding authorities. Without
Bluntly, without anything.
my lordship,
You are innocent.
my lordship, no notice have been served. No.
That I understand.
My lord.
But nothing, no transaction, suspicious transaction.
Alleged instances by the centralized cyber cell branch Patna, they have said that some illegal
Where have you stated so?
My lordship, I have stated in the synopsis of the there.
Where? In the read petition?
Yes.
Body of the read petition?
My lordship, in the synopsis also there, my lordship.
No, in the body of the read.
Yes, my lordship, I have addressed, my lordship. My lordship, page number 7, my lordship. May I read, my lordship? It was verbally and vaguely intimated to the petitioner that the account had been placed in a debit
Which
freeze.
line?
My lordship, sixth number line, my lordship. It was verbally and vaguely.
Second line, lordship, it was starting from the end. Seventh line, extreme right. It was verbally.
It was verbally and vaguely intimated to the petitioner that the account had been placed in a debit freeze, allegedly at the instance of the centralized cyber cell branch partner of the State Bank of India, my lordship. But no notice have been served, no complaint, nothing have been served. So I have given the entire bank statement to the bank authorities, my lordship, regarding that particular day, that particular day things happened. So in that statement, my lordship, nothing have been shown, my lordship. And I have filed a legal representation also, my lordship.
Mr.
Aramin, my lordship.
Petitioner. Mr. DJ Das. Now, Central Government Council for the response number 4 and 5.
Lordship.
4 and 5.
Yes, lordship, 4 and 5.
4 and 5. Postal. Agreed by an action on the part of the respondents, State Bank of India authorities, in keeping the account, bank account of the petitioner debit freeze. The petitioner has approached discovered by the instant petition. The petitioner has stated that he maintains bank account number 44645156684 at Krishnai, branch of respondent, State Bank of India. Post of without the State Bank account has been kept debit freezed without any prior notice by any of the respondent authorities. Issue notice returnable on such. As Mr. Das, 4 and 5, no problem of this extra copies. 2 of these steps upon 1, 2, 3 by speedful. Full stop. It is observed that upon appearance of the respondent or bank authorities, upon appearance are to raise instruction about the region as to why the account of the petition is kept debit freezed.
31st July.
Develop.
Item 11.
Justin. No, where is synopsis?
Fire and
Or is it?
requisition is not taken care of.
Is it not a case under Land Grabbing Act?
Yes, my lord. Moreover, my lord, if not under, if it was been taken.
Yes.
Madam, I'm pass over for the time being. I cannot find my senior.
Who is your senior?
Ardhar.
R? Or ask him to first explain why this writ petition is not to be dismissed. Because of the remedy under the Land Grabbing Act.
Moreover, FIR is of 23.
Whatever, why we, whether we are going to execute and recover the land for him, that Land Grabbing Act is not there.
Yes, it's land grabbing, civil is also there.
Huh?
Civil is also there.
Ask your senior.
Number 12.
May I please, your lordship? Hearing your lordship.
What relief you are asking here?
Regarding the occupation of government investment, years after hearing is done.
Hmm?
Or-
Your prayer is how long? Prayer is more than the repetition, perhaps.
Lordship.
Let us see first. To show causes to where reading the nature of manifestation may be used to set aside the impugn. And next up, full poly.
Evicted on my lord, 8625.
Yes, that is.
And next up, let me first look at the prayer. And next up, full poly. Rejected, already allotted. Okay. And to show that is appealable order. 65, annexure 4 Koli are appealable order?
Yes.
Is it not? Page 65, say for example.
Your Lordship, similar writ petition are pending, Your Lordship. WBC 9326.
That does not bind this court.
Lordship.
That does not bind this court to examine the writ petition independently.
Let it become along with those writ
No, no. That does not bind this court
Yes, yes.
in full force
Yes, yes.
to examine this writ petition
Obviously.
independently.
Obviously.
Yes. First, let me satisfy.
Yes, yes.
It to pending milega, sir. Totally different.
No, no, same.
Totally
Same. Yes, same. Same. Similar petition.
Yes, what similar kind of writ petition is pending?
Your Lordship,
Any order you have next?
No, I am make a statement in para 14
No,
page.
what is your case first?
Page 19.
What is your case?
Now, this was the government wasteland. We are in occupation, Your Lordship. Subsequently, we have been evicted, Your Lordship.
When
And
you were evicted?
Evicted
8/6/25.
21. No,
8/6/2025.
25. Now, this plot of land was allotted to APDCL, Your Lordship. Now, we are not on that. Thereafter, Your Lordship, we have made a representation. They were making arrangement for giving us some unsuitable land, Your Lordship. So we filed a representations that is under consideration, Your Lordship. Now, similar cases are there, Your Lordship, WPC 9326, 1473.
Yes, Mr.
If it is under consideration, my lord,
But
if
there
it is
are
under consideration, my lord, then why the writ petition, my lord?
not
Which
responded
representation
yet.
is
Not responded yet.
which response? What is the
1/12/25, I think.
representation?
Lordship, Annexure 8, page
92.
92, Your Lordship, Vernacular 93. That arrangements are being made to a lot of uninhabitable land situated in the flood affected area of Chirakwa Revenue Village under Atani. We do not wish to surrender our resident land, but we have independent surrendered. Situated at Sorwa Bakra Jingle Village under so and so in exchange of said unsuitable land. Further, we are not willing to accept the flood.
Heard Mr. R. Mojumdar.
My lord, this representation is of 2025, my lord.
Yes, yes.
It says, my lord, the uninhabitable land. Evicted on the 8/6, my lord.
8/6.
8/6.
Yes.
Now their prayer is for the proper rehabilitation, my lord.
Heard Mr. R. Mojumdar, Learned Counsel for the petitioners. Miss N. Bordoloi, Revenue 1. Mr. N. Das,
23456.
Junior Government Advocate, for the respondent for 23456. Mr. B. Das, Land Standing Council APPCL, for the respondent number 7. Post of the petitioners have projected that they settled themselves about 5 decades earlier in government wasteland. Which area? Under
Bakra Jungle Block. Revenue key,
under
revenue tougher.
not even where is that? Jungle Para. Nothing.
Upper revenue circle.
Tougher revenue circle, and that area.
Where it is mentioned,
Not
please
in
for us
Because
them to find out the proper spelling where it is.
the PDSL project is coming under.
It is
Nowhere, man.
Nowhere.
no, that is in the revenue receipt. I have revenue.
No, when they're pleading,
Reading. Reading your lordship is correct. I could not find the specific area, your lordship. Dark numbers are there. But now,
which moja, which moja?
Which revenue circle?
Which revenue circle? Which village?
Moja and revenue circle Chapor, your lordship. Area is
At Sapor, Sorua Bakra,
Jungle
Block, Moja, Sapor Revenue Circle Subdivision, Vilasipara. However, they were evicted. They are from on 8/6/2025. So thereafter, the petitioner submitted a representation dated 1/12/2025. After their application for settlement of those plots of land were rejected, for their rehabilitation in plots of land which are habitable in nature, as the representation is not given, stating that the said representation has not yet been given due consideration. The petitioners are before this court to issue notice returnable on so and so, as so and so appeared accepted. No formal notice, extra copies. So again, 2 openings.
Representations only 5 petitioners.
0308. 3rd August. Daily list, item 13.
Yeah, please, your lordship. Should this matter when it's from a order which your lordship will find at page 29. And pursuant to this order, lordship, my boundary wall has been removed. So what has happened here is, lordship, if I may take your lordship.
I is being conducted with circle officer. Yes.
Now, lordship, I am the pattada of a plot of land measuring 3 kathas. And the adjacent plot is of my husband. So it's in different names. I'm the
Adjacent land is?
of my husband.
Okay.
Now, this is besides the highway, the Gwalpara highway, lordship. And besides our plot, there is a Sarkari Khas land, which is being occupied by some people, lordship. Of course, they are not the patadas. Now, some people made a complaint that there was water logging there. And pursuant to that, lordship, this order has been passed. And in fact, I am not aggrieved by the fact that my boundary wall has to be removed under any condition. If it is my patta land, first you have to see whether there is any other way to make the water go. And if you are taking over my land, at least you have to compensate me for that. My simple prayer is that before your lordship. But first you have to look into what is the government land besides me. If the water can go through that land, in fact, the water logging is in the government land.
Okay. Let notice be issued then.
Yes.
Mr. R.K. Devchuri, Land Senior Counsel, Estate by Mr.
I'm Radha.
Land Counsel, Water Petitioner, and Mr. Ms. Ann Bordula, Revenue 1, 2. Is there any director revenue? Just a minute.
Director, there appears to be.
That's one number 2.
3, 4, 5, 6, I'll be afraid.
Is there anybody like that? There is nobody like that in my locality. This is my locality. So at least I have not come across.
Perhaps that can be.
It might be there. It should be Director of Land Records. That could be.
To be
Land survey and
Land records and survey.
Ah.
Director of Land Records and
That is in Rupnagar.
That is
Rupnagar, it's in Rupnagar.
I do understand, Lordship.
Respond number 1. I'll dispense this respond number 2.
Yes, Lordship.
Mr. Endas, learned junior government advocate for the respond number 3, 4, 5, and 6. Who is this? 7 and 8.
7 and 8 are the persons who had lodged the complaint regarding the water logging. And in fact,
The petitioner has stated that she is the owner of a periodic patta land covered, measuring 3 kathas covered by dag number so and so, old, new, under patta number so and so, old, new, at Revenue Village, Bhaluk Dubi, part 4,
part 5.
part 5, comma. District Gwalpara. Balijana Revenue Circle, District Gwalpara. Subject plot. Full stop. Pursuant to an order dated
Page 29, Lordship.
20/05/2026, within bracket. Respond, Annex 7. Passed by the respond number 4, comma, the boundary wall of the petitioner has been dismantled in order to dug out a drain of 8 feet in breadth and 128 feet in length over the petitioner's patta land, over the subject land, without giving any notice, prior notice, or without initiating any process for compensation. First up, it is stated that the action for dismantling the boundary wall was taken by the order dated 25/2026 on the basis of a complaint lodged by the respondent number 7 and 8. Post up. Issue notice returnable on soils. As Miss Bordolo for 1 and Mr. Das for 6 have appeared, huh? No formal notice. Steps up on extra copies 2 working days, steps up on 7 and 8 by registered post. Speed post. As it is submitted at the bar that there is no authority. Like the party respond number 2 in pleaded hearing, comma, notice is not issued to the state. Respondent number 2 at this stage. The respondents shall ensure that their responses are filed before the recordable.
3rd August, 0308.
So, that's Lordship.
14.
By this petition, Lordship, we have challenged the impute notice of permanent closure of rehab center, Lordship. The Lordship will find the notice is at page 44, Lordship. Here the petitioner.
What is the original order? Page 47.
This is type copy. Original order year 47, Lordship. But this permanent closure of notice has been issued, Lordship, without serving any.
Version 2. Yes.
Without serving any show cause notice, directly
Right.
to issue this.
Yes, Mr. Das.
My lord, show cause notice has been not there one, but it says that it's a physical inspection of your
That
DA.
cannot be. Somebody has criminal activities. That does not mean that the center is involved in criminal activities.
They've already taken a final decision. Without serving
Heard.
any show.
Mr. B.
Halgal.
Halda, learned counsel for the petitioner. And Mr. Endas.
Free and focused.
Who is for social justice?
RM Das, madam.
Where is he?
RM Das.
Not served. Name is not shown.
Name.
Get a copy served.
Yes.
There is the junior government advocate for the respondent number 3 and 4. Post of the land council for the petitioner is to serve a notice, is to serve a copy of the petition to the learned standing council, social justice and empowerment department, government of Assam. By during the course of the day, let the case be listed on tomorrow, day after tomorrow.
In the impute notice, they have stated that they will be permanently closed the immediate effect from Monday today, Lordship, 2nd day of June, today, Lordship. Today itself, Lordship. Therefore, I made a mention on Friday also. Lordship.
The get a copy served, then we'll take up. Inform him. Don't bypass this. Don't bypass this procedure. When there is a standing house.
I'll immediately serve.
Item 15.
My lord, here, my lord, the Assam road project, my lord, was initiated in the Dimahasa district, my lord. And para 3, I have stated, my lord, that initially
How many petitioners here?
10 petitioners.
Well, the
lands
permanent
are-
residents, scheduled tribe, those lands technically have been acquired. And pen art cutting till now. You want to say that no survey has been made?
Yes, my lord, my thing is that, my lord, there is a notification. As per the notification, they have to do everything by a district level led persons committee. Page 102, my lord. Page 87.
Age?
87, my lord. And in 2023, they have done the first measurement, my lord.
Which provision?
4.7, my lord. Page 89, my lord. Clause 4.7. District level committee will prepare the valuation of land and assets. Requisition agency may also define a so and so, my lord, or define categories. So my submission is that district level committee has to be constituted and they have to issue notice for this valuation. And this was in 2023, my lord. First page 102, your lords will find.
Where are your lands?
Lands are there, my lord.
Where have you stated?
We have stated, my lord, paragraph 2, paragraph 3 also. My lord. Since it's, my lord, in the Dimahasa Hill district, my lord, we have.
Affected and
And your lords will find para 5, my lord, all the category of land I have stated. Affected land, my lord.
what happened in the first phase?
First phase, my lord.
You said second phase. What happened in the first phase? Your land have been acquired or what?
In the first phase, they, my lord, made an survey sorry, my lord, in a measurement, my lord, where they stated that your land will go, my lord. In 2020 to 23, they also collected our bank account details, but after that, my lord, physical verification was never done. Then in 2023, my lord, we have annexed one notice, my lord, page 102, my lord. 102, my lord.
102.
Yes. The authority issued re-verification because our land has not been, my lord, actually measured. But we are deprived of the land, so re-verification process notice was there. But this also did not, they achieve anything, did not achieve anything, nothing was done, my lord. So we waited, my lord. So initially there was delayed action, my lord. Then after the re-verification notice, nothing was done, my lord.
But you have annexed so many orders, whether they approached earlier or what?
Earlier in one writ petition, they approached, my lord.
Which one?
Page 116, my lord.
Page 116.
Yes. There were altogether 83, but the petitioner grievance were not touched, my lord.
So these petitioners are not under paragraph 13 or what?
Not under paragraph. We are not even, my lord, been any explanation from the authority regarding.
No, whether your land have been disturbed or what?
Yes, my lord. Land has been disturbed, my lord. Photograph also we have annexed, my lord.
Which one?
Page 49 onwards, my lord. 49 onwards, your lordship will find affected land. And it's a non-cadastral land, so they have to make a survey and proceed accordingly. Now, my lord, may I submit one more thing, my lord? One step ahead, my lord. They after filing the writ petition, possibly Revenue Authority issued one notice to us, my lord. Learned friend is
Joint sport verification, lordship. After receipt of the representation, a letter has been issued for reassessment and re-verifying whether the land of the petitioner really acquired or not, lordship. So, lordship, yes. And accordingly, joint sport verification has been initiated, lordship.
So let them submit joint report, a copy to you also.
Let them, my lord, go ahead with the verification. And my lord, let them make ready for inspection of this court, the said verifications, my lord.
Right,
Because-
and submit a joint report.
Yes, lord.
So a copy should be given to you so that before initiating any process, a copy of the report should be given to you so that you can, because firstly, whether your claim, asserting the claim of the petitioner.
Yes.
And to verify it and to submit a report.
Submit a report.
So you participate.
There is no, my lord, time frame is given. So
At the earliest until this thing, there should not be any further taking over of the land.
no, lord, yes, lordship.
After issuing this letter, a joint spot verification has been taken place on 19th. But I have been verbally been informed that the petitioner, they were not cooperating with the officials who have visited the spot.
Then it will be
and even they have
not
also,
correct if
even
they do
after-
not provide assistance.
Lordship, they've also received
That is
the
wrong,
notice.
my lord. He is, my lord, from
Verbally.
revenue.
It's a
Why
verbal-
should we enter into that then? If a verification process is underway,
My lord, kindly see the second page, my lord.
get the proper instruction, written instruction.
Yes.
We'll proceed further.
Lordship may issue notice, second phase, my lord.
No, no, all the time should not be issued notice just at the instance of filing a petition.
Well,
If the joint verification is underway, if your interest can be protected there and there, why should we enter into that?
No, let them go, but
Let them go, let them complete the joint verification report where you should give your assistance. And thereafter, any survey should be there so that you can make a claim for compensation at a later point of time. Or at the immediately thereafter, after joint report.
But my
But
submission,
why
my lord.
should we stall the entire thing?
No, Lordship may let them go, my lord. Lordship issue notice and let them make ready of this assessment for examination of this court, my lord. Because 23 also in 2023, re-verification was not done, my lord. And they delayed the process and we are deprived of. The land art cutting is going on. So everything within the purview of honorable court, my lord, because it's a
Why we should monitor everything?
No, just
we are not the monitoring court for all this. Something, if
That's
something
why
can be
the
done, heard Mr. B. Burwal and counsel for the petition and Mr.
D1000, Lordship.
Posto. For Land Standing Council,
Dimahasa,
Lima Hasa
Autonomous Council.
Autonomous Council for the respond number
226 and 9, Lordship.
226 and 9. Also heard. Public Works Department is available. Miss A. Bota. That's Standing Council, Public Works Department for the respond number 1. Who else? District Commissioner. District Commissioner. Where is Miss A. M. Bourbon? 1 and 8. And Miss A. Bourbon, learned junior government for the respond number 7. Post of. It is stated that the respondent authorities are presently undertaking a project of improvement and upgradation of the road from Haflong Tiniali to Lower Haflong under the Assam Mala project. First of the petitioners, any number, have projected that the plots of land, owned by them, are by the side of the said road, and in the process of undertaking the project, the petitioners, plots of land are
Verified, my.
in the purview. Post of. The petitioners have projected that the respondent authorities in the Dimahasa Autonomous Council have resorted to art cutting since the month of May 2026. And have they taken over your land?
Yes, my lord, that is the thing.
And the standing properties of the petitioners
Affected, my lord.
have been affected in the process. Post of as no compensation, as no survey, no proper survey has been undertaken by the respondent authorities prior to destruction of the standing properties standing on the petitioner's plot of land. The petitioners had complained before the respondent authorities and had asked for a survey before undertaking any works under the works for improvement and upgradation of the road under the Assam Mala project. First of issue, Mr. So-and-so, Learned Counsel for the Standing Council. The Mahasa Autonomous Council has submitted on instruction that on 9/6/2026, a joint spot verification has been ordered by the respondent number 6 to verify and ascertain the claims of the petitioners by visiting the spot and inquiring the matter in detail in consultation with the officers of the Public Works Department, Haplong Division, and the engaged contractor in presence of the Gauhati of the concerned villages, and to submit a joint report thereafter at his office. Post of Mr. So-and-so and Standing Council has further submitted that on 19/6/2026, a joint verification, spot verification, has been done. Post of, in response, Mr. Borua has submitted that in the said joint verification report, the participation of the petitioners was not asked for. Post of the matter required consideration, issue notice returnable on so-and-so, as so-and-so has appeared, accepted notice, formal notice dispensed with, extra copy within 2 working days. As a joint verification has already been is being undertaken, the respondent authority shall ensure that has ensured that in the said joint verification, the petitioner's plot of land, it is to be ascertained whether the petitioner's plot of land as this. Have you described your plot of land? Huh? The respondent authorities shall ascertain whether the petitioner's plots of land have been brought under the purview of the project of improvement and upgradation of the road, and to what extent. Respondent number 7 wrongly. It is Dimahasa district only. Wrong, huh? The name of government advocate, learning government advocate Assam is to be reflected in the respondent's agreement.
5th August. Item 16.
Yeah. 17, 18 similar GST cancellation matter.
Huh?
GST cancellation 16, 17 and 18 matter.
You filed a revocation
Yes,
in time.
In time, my lord. That's my lord.
Not a
proposal
GST
issued
cancellation. You have
7
to.
days time, my lord.
Huh?
The so-called was issued, why this revocation shall not be rejected, my lord?
Huh?
The 7 days time was given, we could not reply in the time, that's why, my lord, that was rejected. Lordship will find the order at page 40, my lord.
The GST account. Let us see first notice.
So-called notice, lordship will find it page 18, my lord.
Then order of cancellation,
Page 19, my lord.
page 19.
My lord.
Orders, effective date of cancellation is 1911. Then when,
After, my lord, we file all our returns.
why the revocation procedure?
My lord.
Section 23.
Just,
We'll try to examine at the end.
my lord. My lord.
Second half.
Lordship.
16, 17, 18.
Item 20.
What kind of transaction? Have you stated anywhere? Apart from all these violation of provisions of BNSS, CRPC, have you stated?
Page 17.
Page 17. Yes.
It's a statement, bank statement, Lord.
Yes. On inquiry, what you were told?
They have, the bank authorities told Lordship it was frozen by head office of the Canara Bank. But Lordship, even though there is no any disputed amount, Lordship.
Heard, Mr. M. Ali, Learned Counsel for the petitioner. The petitioner stated that he maintains a current bank account number 120033204623 at Gauhati branch of the Canara Bank. First off, the petitioner is approached this court by the instant information stating that the said bank account has been kept on hold by the respondent bank authorities without any kind of prior notice. Issue notice returnable on so and so steps by speed post within 2 working days.
0508. 5th August. Item 21.
Regarding allotment and settlement of land, brother, my lord, page 16, the minute. Page 16, the minute of the SDLSC meeting, my lord, whereby
Page 16.
16, my lord.
Serial number?
Serial number 22, my lord, in vernacular, my lord, page
Not
19.
in vernacular. It is in English only. Heard Mr. M. Hussain, Learned Counsel for the petitioner. And Ms. M. Bormon. 1, 3, 4, and 5, and Ms. N. Bordoloy. Revenue 2, post of by resolution number 22. By adopting resolution number 22 in a meeting held on 18/11/2025. The Sub-Divisional Land Advisory Committee,
Yes.
Bilasipara Subdivision, approved an allotment proposal of government khas land measuring 4 katha as and 17 lesas, covered by dag number 255 at village Surjo Khata, Devattor Hat, page 19, non-agriculture town, in favor of Bilahipara Jame Masjid, Bilahipara. Post. As after the said approval of the SDLAC, the settlement allotment proposal has not been brought to a conclusion. The instant writ petition is preferred. First of the petitioner has projected himself with the president of Bilasipara Jame Masjid, Bilasipara, and it is stated that he has been authorized by the executive committee of Bilahipara Jame Masjid, Bilahipara, to file the present writ petition, seeking a direction, indirectly a direction to the respondent authorities to complete the process of allotment of the subject land in favor of the Jame Bilakipara Jame Masjid, Bilakipara. Issue notice returnable on so and so, as so and so, so and so, if you have extra copies to open this.
0508. Item 22.
Against a general notification for removal of hoardings, uniforms, etc. General notification is there. Lordship will kindly see page 20. There is a PIL order which says when you formulate a policy and guidelines regarding hoardings, etc. Page 20.
No,
20.
Before Manus, you can start, madam. That last occasion, not on last Friday also, similar petition was moved, madam. Here also, GMC is not a party.
GMC not part?
Only the commissioner is with party, madam.
Yes.
Oh. I dismissed that.
Yes.
Well, GMC commissioner is party, my lord. Lordship will kindly say,
Yes, commissioner
it
is
is a
party.
notification, it is a notification issued by, my lord,
It should be
page
GMC
48.
represented by
No, I'll
commissioner.
correct it, my lord. There is no issue, my lord, in that regard. It is a
Correct it.
notification issued by commissioner special
Correct
secretary.
it, because I am bound by my own order also.
I'll correct it, my lord. This general notification has been issued by the commissioner. And
No, I
special
correct it.
secretary.
Same thing
I'll correct it, my lord.
I dismiss it. I am bound by my own order.
Well, it
I
will-
cannot take two different. You correct it by tomorrow, I'll take it. No issue.
That is fine.
File an amended cost title today itself.
Yes.
Right? Let it come tomorrow, my lord.
List the case tomorrow.
Same as the item number 20.
Because
25.
I am also bound
I understand.
by
But this is
procedure.
a general notification, my lord.
I'll look into it. File the amended cost title today itself.
Item 25 also similar.
25.
Right.
Okay.
Well, let it come up tomorrow, my lord.
List the case tomorrow.
What cost?
23. Item number 23.
This is 8. Okay, 8 is also the same party.
Same matter, lordship. The in lordship, item number 23, lordship.
Let us see then 8.
Yes.
8.
Lordship, the petitioner before the lordship is a registered dealer under Assam GST Act, lordship. The summary so-called notice was issued, lordship, to the petitioner, lordship.
And there are the summary assessment order was passed.
When is the impugn order? Where is the impugn order?
Lordship,
Where is the impugn order?
Lordship. Also, order at annexure 5, Lordship.
Annexure 5. When it was passed? 26/4/2024.
Lordship,
We are after 2 years.
Lordship.
Now the maintainability will be considered. Because what did you did
Lordship, and
after this impugn order?
Eh.
Similar order.
Lordship,
First, you have to cross the bar of limitation.
Lordship,
I have understood
Lordship.
recently a writ petition is maintainable
Lordship.
even if there is availability of alternate statutory remedy of appeal. So this is an appealable order, right?
Lordship.
Mr. Gugoi,
Yes, sir. In fact, Lordship.
right? When there was a specific period of limitation,
Lordship.
right? If within that period, the writ petition is preferred, that availability of alternative remedy is available. But if it is beyond,
Lordship.
then there is no availability of alternative remedy. So whether Supreme Court has said under Article 142 also, because of public policy, we cannot condone. Not to speak of under Article 32 or 226. Now cross this bar. You have to cross this bar. Don't show me coordinate bench judgment. Whether that issue has been dealt with or not.
107.
107, 3 months plus 1 month, 4 months, extended period, 1 month. 4 months, that expired long back. So there is no availability of alternative remedy as on date.
Lordship.
Clear?
Lordship.
Now tell me whether in such situation this writ petition can be entertained or not. If not, it is to be given a burial or not.
Lordship, I am not going to that
Ah.
aspect of the matter, Lordship.
We'll issue notice, but we'll decide
Lordship.
on this maintainability.
Lordship will record that part, my lord.
Yes.
The maintaining the point open.
Heard. But no interim order.
Lordship, no coercive measures should be taken. That much.
No interim order.
Lordship, in other repeaters, Lordship notices were issued day before yesterday, Lordship.
Huh?
And
No, taking into account this point.
Lordship, in other cases, Lordship,
So me, because by course of time, I also learned.
Lordship. Not by your Lordship, not by the that's right.
Then on this point, I don't think. Mistake committed can be corrected. After you satisfy me on the returnable date, I will pass on 13/11/13/7. Because for 2 years, there was no coercive action.
Lordship, that was not.
You continue with it. So delay, then I'll decline that. Heard. If you press for it, I'll decline because of the delay and latches.
Lordship, the petitioner is a very small dealer, Lordship.
Heard.
And that is not within his knowledge, Lordship.
Lack of knowledge is not a defense before a court of law. Heard, Mr. S.K. Agarwal, learned counsel for the petitioner, and Mr. B. Gugoi, learned standing counsel, Finance and Taxation Department for all the respondents. Most of the petition in this writ petition has essayed. in this writ petition, preferred under Article 226 of the Constitution of India, has essayed an order in originals dated 26/4/2024, passed under Section 73 of the Assam General
GST.
Assam Goods and Services Act 2017. Full stop. On what ground?
Lordship, the personal hearing was not granted, Lordship.
The petitioner stated that no personal hearing under Section 75(4)
Lordship.
of the Act has been granted to the petitioner prior to passing the impugned order in original. So, Mr. Gogoi, Land Standing Council, Finance and Taxation Department, has submitted that under section an appeal was maintainable under Section 107 of the AGST Act, CGST Act 2017, within a normal period of 3 months and an extended period of 4 months from the date of communication of the impugned order in original dated 26/4/2024. First off, but the petitioner did not avail the remedy of appeal within the said period of limitation under Section 107. First off, and waited for more than 2 years to prefer the instant writ petition under Article 226 of the Constitution. First off, he has contended that once the period of limitation under the special enactment, which stands excluded by operation of Section 29(2) of the Limitation Act, no period is contemptible for entertaining the writ petition. First of para, issue notice returnable on so and so 13/7.
Till then, your Lordship.
13/7, first of. As Mr. Gogoi has appeared accepted, no formal notice, extra copy within 2 working days, hired the learned counsel for the parties on the interim period. First of, as the petitioner has waited for more than 2 years to prepare the instant writ petition against the to assail the impugned order in original dated 26/4/2024. It primarily appears that the petition, the action of the preference of the writ petition is suggestive of delay and laches in any such view of the matter. No interim prayer, no interim relief at this stage is called for.
Lordship, in other cases, Lordship, the interim period considered like
Appeals.
in Kiran City Hotel the day before yesterday, Lordship.
No, that is, I counted.
Lordship.
I counted the period.
Lordship.
If you go by my order, I
Lordship.
counted the period and I have observed.
Lordship. Both the matters are same, Lordship.
Same.
Yes.
Order dated
30/12/2023.
Mr. Gogoi, please find out
Yes, sir.
what is the law,
And that
whether we can condone the delay.
Lordship. One judgment is always there, Lordship. You should refer my lord in every case now. My lord. Then I will paste them.
That has been confirmed by other Supreme Court judgments.
Lordship.
Unless there is some other proceeding by petitioner.
Lordship.
24.
Same 2 years delay. At this stage, I said at this stage.
Lordship.
You satisfy me, I'll grant you.
Deeply obliged, Lordship. Item 24.
Yes.
Please, your Lordship. Lordship, in this case, the petitioner, Lordship, praying for mandamus for permitting the petitioner to petitioner.
Item 51.
Nodal officer? Impleaded?
Yes, ma'am.
Heard Mr. R. Amin, learned counsel for the petitioner. Mr. Endas? Learned Junior Government Advocate for the responding number. Six. Full stop. The petitioner has stated that he maintains a bank account number at Mongolway branch of respondent SBFC Bank Limited. He has been maintaining since 1/8/2019. Post of recently, the respondent bank authorities have put the state bank account in freezed condition. When?
It was 22/08/2022, my lordship.
Oh, 28/2/2020, not recently.
My lordship, 8/08/2022.
2022.
Yes, my lordship.
08/08/2022. You should notice returnable on.
But same has been communicated to me, my lord, 4/4/2025.
No, it is more than 4 years. Issue notice returnable on so and so. As Mr. Das, respond number 6. No formalities, extra copies. Steps upon the respond number 1 to 5 by its speed post. We need to work in response to that. Let us see.
708, 7th August.
Gogoi has come. Okay. We'll take up at 2. So, for being late because of a meeting.
Daily list item 24.
Your lordship, I would like to mention item 49.
Not at this time. Advocate General. Some or the respondent number 1 to 4.
Yes.
And Mr. K. Gogoi, learned public prosecutor. For officer in charge?
I know.
For the respondent number 5. Full stop. In this petition, the petitioner.
Supplementary list item 52.
Yes. What is the code? Yes. Yes, madam.
My lord, I'm appearing for respondent number 2 to 5. I have just been engaged, my lord, yesterday. I seek some time to file my wakalat.
Why, on the day Mr. Das was there?
They have appointed me newly. Just yesterday I have been appointed and I have to submit my file my wakalat nama.
Change of events, Mr.
Lordship.
Sharma.
Lordship.
When do you want?
My lord, post the summer break.
Lordship.
Huh? Oh, no. This is not a case for post-summer break. By change of counsel. It is not an issue, that major issue. You have to take instruction whether this, as per the terms and conditions, whether. Yes, Mr. Sharma, please.
Yes. The fact
Tell
of the
your case.
Yes, the facts of the case is that the petitioner is the owner of a tea estate. And
That I have understood.
yes, your lordship.
Now,
your
what is the minutes?
The lordship.
Minutes, what is
Yes,
your
please.
undertaking?
First-
What is your
first-
undertaking?
First, your lordship will find it page 42.
Which part?
Page 43, the last part, serial number 4 and 5. First, the AT, that is the respondent authority, request to take necessary action upon clearance of all separate due into the matter of attachment, which I did. Then number 5, in the event that the receiver.
No, come to page 54.
Page
54.
54. Lordship, the minutes of the second meeting, your lordship.
Yes.
Yes, now the 1, 2, 3, 4th paragraph from top, your lordship.
Question is deposit of 3 crore.
Yes.
72 hours. as a security measure,
Lordship.
right? Deposit of
Lordship.
3 crores. It is not the deposit of checks as a security measure. There is slight difference in between,
Difference, Your Lordship.
right?
Yes, Your Lordship.
So to that extent, I don't think.
That is why that.
Deposit of 3 crores with ATPFO. That is your willingness.
Understood. Understood, Lordship. That is the decision of the meeting. Understood. That is why if your Lordship may kindly come to once,
Question
only
is
once.
about the projection made about that checks were deposited as a measure of security. No.
Lordship.
Deposit of 3 crore as security.
Lordship. Understood.
I don't think.
Yes, Your Lordship. But
Well, you
to
should not be
clarify
at this
that-
stage.
To clarify that, Your Lordship, may kindly come to page 42 once, Your Lordship, 43 once. How this thing evolved, Your Lordship, regarding the security thing. Everything will be clear, Your Lordship. Serial number 5 at page 43.
But this is subsequent 54.
Subsequent. I'm coming to that. This is only just 5 minutes, Your Lordship, will be with me, Your Lordship. I'll satisfy Your Lordship.
No 5 minutes is available.
Serial number 5, in the event that the receiver's accounts are not finalized. If it is not finalized, then within the stipulation.
Will not allow them to release it to the who is that receiver?
Lordship, my only grievance here.
No. Your case is different, Mr.
Lordship, my
Sharma.
only grievance here is that this is first and foremost not a recoverable due. As per the law, the statutory dues, whatever I have paid, this is only on the basis of the minutes of the meeting that they have got the right.
No,
and
Mr.
I agree.
Subject to
I agree.
auditor's report, liability of that will be subject to audit.
Lordship.
Right.
Lordship.
We will not allow them to release any money to the auditor or receiver in the
Lordship.
meantime.
Lordship. The only thing, Lordship,
No, don't change the case.
No,
before
I'm
the
not changing, Your
court.
Lordship.
Hi, Mr. P.K. Sharma.
Lordship, my humble prayer, only one thing, Lordship. I am already running there's a huge
Run it.
financial burden. I don't have 2 crores as of now, and I have already.
Then why you have undertaken that?
That's why they have. Then after that, we changed that.
It is not that they are releasing the money.
Then Your Lordship, the impugnator, Your Lordship may peruse the impugnator only. Why I am apprehensive, Your Lordship. Page 67. Page 67. Now, before that, if Your Lordship may kindly come to page 65 once. Page 65. Subsequent to the meeting. Page 65. By this order, the attachment was withdrawn. Your Lordship may come to the second paragraph straight away. But now, the owner of Sandana Tea Estate so-and-so have cleared all the area PFDs and also submitted security of 3 crores against the expenditure incurred during recovery process, which is subject to audit. So, from their language, the earlier language and
Subject to audit, that release is subject to audit, Mr.
yes,
Sharma.
and they are satisfied that I have submitted 3 crores.
That I have understood.
Otherwise, they would not have withdrawn the attachment. This is my only submission, Your Lordship.
I have understood.
Yes.
No, don't change that willingness to. The question is
Lordship.
Not the deposit of check as security.
Yes. It was 3 crore deposit.
Deposit of 3 crore as security.
Yes, Your Lordship. Yes.
Now you are trying to
I'm not.
change that deposit of check as security.
No, I'm not.
That is not the case.
No, this is not the
We can only say that if it is, that is your concern. Whether these are
I fully agree.
honored or not honored, that is your concern. But there is nothing. We can only observe that subject to audit, no amount is to be released to the receiver.
I
That's
fully
all.
agree with Your Lordship. I agree that I'll deposit that much is agreed, Your Lordship. But Your Lordship may also
I heard
kindly
Mr.
come.
P.K. Shall I? Mr. Sharma,
Lordship,
I have understood your case.
I agree, Your Lordship.
First you have undertaken,
Yes, Your Lordship.
shown your willingness.
Yes, Your Lordship.
And deposit of 3 crore.
Yes.
Clear?
Lordship. I agree with Your Lordship.
Not deposit of check as security. Deposit of 3 crore as security.
Exactly, Your
That's
Lordship.
all.
I agree with that.
Subject to audit. Receiver fees.
Lordship, but I agree with Your Lordship. I'm not denying that I have agreed that to deposit, Your
Not
Lordship.
hardship is not a case to be propounded here.
Your Lordship, at
I
page
understand.
18, I have annexed the document. I will be getting money from them. It's the other way around.
Let it be kept in deposit without any.
1 crore, I have 1 crore is not a
That
small.
is not the case. Then why you have come here?
Your Lordship, they have. Why is the receiver reluctant to give the accounts? They could have given from time immemorial. He has been asked to give the accounts. This is not giving. Why should I suffer for that, Your Lordship? His only thing is that he had to submit the accounts so that audit can be carried out. The receiver is not submitting the accounts.
because he's not entitled to any money. Instead, he is supposed to give me money, return money to me. There was a surplus. He earned money from my garden by not paying a single expenditure. He has never paid the labor wages, never paid the rations, nothing. So entire thing he has galloped, Your Lordship.
Then why you have gone to the meeting and made the undertaking?
Because I needed the garden. I needed to run the garden.
Now you have the liberty to turn back.
No,
Heart
Your
Mr.
Lordship. Lordship,
PK
the
Sharma.
undertaking is there.
Learned Counsel
I'll
for
pay
the
whatever
petition.
money is there.
And that is not the undertaking, Mr.
1 crore I have deposited also, Your
That
Lordship.
is not the
My bona fide intention.
honoring the undertaking.
I have bona fide. Everything
That-
started from my undertaking.
Bona fide, yeah, I am not against you, but the undertaking is clear. Undertaking is clear,
Lordship,
not the check,
I agree on that. Your
not the check.
But
The
subsequently,
amount of deposit of 3 crore.
because they have agreed for the sake, that is why the attachment
Then
was withdrawn.
we'll issue
Otherwise,
notice
they
only.
would have withdrawn the
Heard
attachment.
Mr. PK Sharma, Learned Counsel for the petition. And Miss
NN Ahmed,
Learned Counsel for the respondent number
225.
225. Also heard Miss M. Borman, Learned Junior Government Advocate, Assam, for the respondent number 1 and 6. Full stop. The petition has approached this court by the extended petition assailing a letter dated 10/6/2026 with in bracket annexure 60 issued by the respondent number where is it?
Number 2, Your Lordship.
Respondent number 2. Issue notice returnable on funds. As Bormont, one is and Miss Swales for the Swales. No formal notice. Extra copies within 2 working days. Issue notice also in the interim period.
7th August 0708. Item 53.
Yes, Mr. Mahmood Munawar.
Yesterday, Your Lordship was pleased to direct us to produce the notification.
DDN 53.
53.
From this notification, it transpires that it is Director of Land Records
Yes.
and Survey.
Appeal should be filed before that. Now, earlier there was a notification. Accordingly, Miller, we have filed appeal before the commissioner. But subsequently, it has been changed, Miller. So, Miller, my limited period, Miller, we will file appeal before the approved period. And till disclose the appeal, the petitioner may not be, Miller, disturbed, Miller.
So that appellate authority, I will dispose of that. Appellate authority will consider your case for interim review.
Yes. Or Miller,
That appellate authority.
or Miller, till disposal, Miller, status as on today with regard
Or
to
that once I pass an order, I cannot pass any interim order.
Well,
Once I dispose of the writ petition,
Miller.
the interim order of any nature is not called for. That I can say that appellate authority on filing an appeal, if it is empowered, will consider the interim period of the capital.
Yes.
The appellate authority will consider.
Yes.
I cannot keep a blanket stay order.
Yes, I am deeply obliged.
Right.
Yes.
All the cases are same.
Item 53.
Okay, heard Mr. M.U. Mondal, Learned Counsel for the
55.
petitioners.
Similar.
Mr. Nath, you are for?
Well, the Lordship, I am appearing for respondent number, just a minute.
Senior Government Advocate for the
One,
respondent
three,
number
four.
1,
1, 3, 4, and 5.
3, 4, and 5. Aforesaid, Revenue and Disaster Management Department for the respondent number 2. Yes, Borua, Learned Counsel on behalf of Mr. B. Das, Learned Standing Counsel APDCL for the respondent number 6.
Plus 7 and 8 also I appeal.
Okay, 7 and 8. To stop. Para. The petitioners have stated that their grandparents, stroke parents, they, either they or their grandparents or parents were allotted plots of land measuring 1 bigha each for homestead purpose at village Sorua Bakra Jungle Block. Sapor Revenue Circle?
Sapor Revenue Circle.
Sapor Revenue Circle. District?
District Dhubri Mane.
Dhubri, Assam. In the years 1987 and 2005.
And 89 also.
Okay, 1987, 1989 and 2005. Post. However, comma, on being allotted the plots of land, the petitioners started, the family of the petitioners started residing in those plots of land. Post of. Where are the minutes?
Minutes will at page 67 lordship will find. First.
Okay. However, in a meeting held on 26/1/2025 of the Jurisdictional Land Advisory Committee of Bilakipara Co-District, a huge parcels of land were allotted in favor of the respondent Assam Power Distribution Corporation Limited for the purpose of setting up a solar power plant.
Power plant.
Post of. Thereafter, comma, by a notice dated 12/6/2025 issued under the hand of the respondent number 4, the petitioners were informed that the allotment certificates issued to them or to their predecessors were rejected due to non-conformity of the stipulated norms and conditions laid down the allotment certificates without informing the terms and conditions which are stated to be violated. Post of. By the notice, comma, the petitioners were asked, the petitioners were informed that the following parcels of government lands were allotted to the APDCL for a power project, page 97. A to A. In the notice, comma, the petitioners were asked to show cause and to file representation along with supporting documents within a period of 15 days on the premise that their occupation of the plots of lands were unauthorized and illegal. Post of. And when did you file?
Not within 10 days.
No. About any application for settlement?
RTPS, yes. RTPS lordship will find at page 32. Page 32, my lord, one of the RTPS has been.
Okay. During the interregnum, during the intermediate period, the petitioners had submitted application for the notified public service, quote, allotment certificate to periodic patta before the designated public authority under the provisions of the Assam Right to Public Services Act. And those applications were duly received with acknowledgements, which are annexed as annexer.
It's annexer 3 series.
3 series to this writ petition. First of. Then, where is your appeal?
Appeal, my lord, not yet filed, my lord. We will file appeal, my lord, before that.
Para. As these applications are not rejected.
Yes, this application they have not filed.
Okay. As the applications of the petitioners for the notified public service, quote unquote, allotment certificate to periodic patta were supposed to be extended within a period of 90 days from the date of their submission. The petitioners were waiting for the outcome of their application. Post op. Despite submission of their applications in the month of February 2025, an elapse of the stipulated period of 90 days for consideration, the notified public service has not yet been extended to the petitioners. Neither any speaking order has been passed as mandated by the provisions of the Assam Right to Public Services Act 2012 as amended. Full stop. Para. So, the Assam Right to Public by notification dated 9 July 2024 of the Revenue within bracket Reforms and Disaster Management Department Government of Assam, which was published in the official gazette on 12/7/2024, it has been notified as regards the notified public service conversion of allotment certificate to periodic patta as under a table from video. Section 8 of the Assam Right to Public Services Act 2012 has provided for a remedy of appeal. Post of Section 8(1). Section 8 of the said act reads as under. What prohibition? Para. As the grievance raised by the by the petitioners in the present writ petition is with regard to non-disposal of their application for the notified public service. The petitioner has an alternative, adequate and statutory remedy of preferring an appeal before the appellate authority, that is, first appellate authority, that is the Director of Land Records and Surveys, Assam. Full stop. Therefore, the writ petition in the given facts and circumstances is not entertained, reserving the liberty to the petitioners to avail the remedy of appeal under Section 8 of the Assam Public Right to Public Services Act. So with the petitioners desire to file, intend to file such appeals, the same shall be filed before the first appellate authority, the director of so-and-so, within a period of 30 days from today. And such appeals are filed. The first appellate authority shall entertain the appeals without notwithstanding any provision as regards limitation. Anyway, you are not serving in the case, not extending the service.
They have, that instruction I don't have. Anyway.
Okay. The appellate authority, first appellate authority shall entertain the appeal and consider the same on its merits. First of, as the petitioner are raising an apprehension as regards eviction, have raised an apprehension that the respondent authorities are contemplating their eviction. The first appellate authority shall also consider such interim relief if prayed for by the petitioner on its own merits and pass an order thereon. Right? With the above observation and directions, the writ petition is disposed. Pass an order on merit. And that authority is not a party also here.
Yes, that is also.
Second one.
May I pray some time bound period?
1 month.
1 month.
1 month you file the appeal.
Our consideration, considered by the authority.
In terms of the provisions, within time period within the time period as stipulated in the Assam Right to Public Services Act.
That's developed.
Here?
Yes.
Second one.
Yes. Similar, only land measuring, here 6 bigger, 2 got a 10 less.
Second one is what? How many petitioners?
Yes. Here 2 petitioners,
2 petitioners.
Yes. Allotment.
Now here it is rejected.
Yes.
Is it rejected or not rejected?
It is pending,
Not pending, pending before some other authority.
Pending before the district commissioner.
That is not the appellate authority.
Yes, it is not appellate authority. Anyway, we will file appeal before the appellate authority.
We'll simply say that
only land measuring is different, Dag number, pata number different.
we are not recording dag numbers, pata numbers here. We have simply have said the story regarding that jungle block. Ekekini hobo. Same director of land records and so.
It is not jungle block. It is different circle under Dugri revenue circle. Dugri revenue circle.
Power project?
No, power project.
Power project is not here.
Not related.
Okay then.
This is not for power.
Okay then. I thought it is power project again.
No.
The synopsis lordship will get the.
Third, Mr. M.U. Mondal, learned counsel for the petitioners. Mr. D. Nath, learned senior government advocate for the respondent number 1, 3, 4, and 5, and Miss Ann Boduloy, learned standing counsel revenue department for the respondent number 2. Full stop. Para. It is the case of the petitioners, twin number, that a parcel of land measuring 6 bighas, 2 kathas, 10 lesas, covered by government dag number.
Yes.
Government dag number 405, at village Adabari, part 2. Or 405 old, stroke, 762 new. at village Adawari,
Otherwise,
part 2,
part two.
Dhubri Revenue Circle, District Dhubri, Assam, subject law. Was allotted in the name of Samser Ali and Zamser Ali, within bracket petitioner number 2. Full stop. The petition number 1 is the son of late Samser Ali. Full stop. The allotment order was issued on 16/4/1976 under the hand of the respondent number 3. Full stop. It is the further case of the petitioner that since the date of allotment, the petitioners are in continuous occupation of the said allotted plot of land. Full stop. Where are your applications?
Yes. RTPS, my lord. At page 30.
Para. Seeking the benefit of the public, notified public service, quote, conversion of allotment certificate to periodic patta. The petitioners, individually or one?
Jointly, my lord.
Okay. The petitioners submitted an application on 24/10/2024 and the receipt of the said application was duly acknowledged by acknowledgement number, page 31. First, when the petition, when after the submission of the application, the petitioners tried to find out the status of processing of the application for the notified public service, which was to be extended within a period of 90 days from the date of submission of the application, in the designated portal stroke comprehensive citizen platform, quote unquote, Seva Setu, it was shown that the application are still pending, is still pending. Full stop. As per the provisions of section, as per the notification, notification, a notification official gazette, then Director and Land Revenue, Director of Land Across and Survey, Assam, Appellate Authority. Same.
Developers.
Then
item 55, my lord, similar to this item, my lord, only land is different.
Belal.
Yes. It has been filed.
Okay, I have not
Bilal Haq
recorded any finding. Their statement I have said it is pending, shown to be pending. Shown to be, let them file appeal for non-delivery of service and not passing a regional order. No, we are not dealing with that appeal. file before district commissioner or state commissioner?
Lordship. They
No,
will file fresh
we are
appeal.
allowing him to file the appeal before director of land records.
Yes, yes.
Oh, only that much. We are not observing on that his earlier appeal before Commissioner and Secretary Disaster Management or Assam State Commission.
Yes.
We are simply saying that let him file appeal before the appropriate appellate authority. No point. They have filed it before a wrong authority. So no point dealing with that. Let them file the appeal before the appropriate authority. And let the appellate authority deal with the matter.
Yes.
Yes. Item 55, my lord, identical, only land and tag number will be different.
Fine. Okay. Same then.
Yes. Dhubri district, my lord.
Dhubri district, silo.
And 56 is similar to item 53, my lord.
53.
Yes.
Power project.
Power.
Okay, power project.
No, Lordship, not similar. As because their allotments orders are here, there is no such allotment. It is Bedokali Jorimana. Page 24.
But
Earlier one also Bedokali.
But RTPS is there. RTPS is there, but not similar, as because their allotments orders were there.
Page
But they have
39,
stated that they have been allotted.
Page 39, lordship will find the RTPS which are pending. Page 39, my lord.
Page 24, these are Bedokali Jorimana, though they have stated in the synopsis, in the writ petition also that
Lordship, kindly see page 39 first.
RTPS আছে too. Yes.
একটু appeal file করি।
Wrong statement না, সেইটো দেখুৱাব লাগিব তো। একেলগে মাৰি দিছে। Copy paste কৰোতে হৈছে ভুল। Here they have not annexed the allotment orders.
They are seeking that service allotment certificate. Let them produce before the appellate authority. Why will you
No,
bother?
no, Lordship, but it's my duty to show you before Lordship.
They are saying that I have said that they have projected that they were allotted certificate. Let them
Lordship,
go.
Lordship.
And they are seeking that service only.
Yes, Lordship.
That service only.
Appeal, Lordship. Yes, yes.
Support revenue circle.
It is.
Yes.
Same.
53.
Same to item 53.
Here the RTPS, Lordship.
If they fail on allotment certificate,
Lordship.
everything will fail.
RTPS to given number base.
RTPS service.
90 days.
Yes.
No, no, page number.
Within 90 days.
Page 39, my lord, RTPS start.
Same silo.
Well,
1 month you file the appeal.
Timing method, item number 11.
Yes. Yes. Why your petition should not be dismissed?
Lordship, if your lordship comes to the representations, lordship.
No, when a specific remedy is available, why represent it?
Representation were filed at page 38 onwards, up to 52. Those representation was not taken care of, lordship.
Who has encroached your land?
That land mafia, sir.
Then it is land grabbing. Not government. Not government.
Not government, not.
24 my lord. It's 26 now. FIR is also 24 my lord. FIR my lord and the representation.
No, what is the prayer here?
FIR is 23 my lord. Now I think all land building selling over.
Oh,
My lord, building has been also constructed. Now remedy is civil suit my.
The allegation is encroachment of periodic patta land. And the allegation is not against the government.
Yes.
Against mafias.
Individual.
And for that a specific act is available. Should you observe something while dismissing it? From the projected case, it appears to be a case of some land grabbing. No? Land grabbing.
Since lordship, we have filed several representations.
Representation don't show me
Those
representation.
were not taken care of, lordship.
Should not be taken care of. Should not be taken care of. encroachment of private land, how government comes in the picture? Either civil suit or
Yes, yes.
land giving act.
It's better, my lord, or limitation will also go because the FIR is of 23. Title already clouded, my lord. Possession gone. Only remedy civil, my lord.
Heard
Observation will be given also.
the learned, heard Mr. Ard or learned counsel for the petition. Miss N. Bordo, standing counsel, Revenue Department for the response number 1 and 2. And Mr. N. Das,
3 to 7.
advocate for the response number 3 to 7. The petitioner has stated that his father, late Topnarayan Singh, and one
He is alive,
late,
Lordship. Top Radha Singh is alive.
huh? Alive?
Yes.
Okay, father, Topnarayan Singh, and one late Bindeshwari Prasad owned a parcel of land. How much? No description, how much? Under
Various.
Peratutas. You don't even know dark numbers also. Others.
Several.
Others.
Several numbers.
Others.
How much land also is not there, my lord.
Not there.
Neither is.
So it is the further case of the petitioner that in the settlement operation carried out in 1955, after settlement, there had been encroachment of those plots of land. At village Udal Bakra, Moza Beltola, Guwahati Revenue Circle. Guwahati Revenue Circle or something else? Kamrup Metropolitan District. Post office. From the projection, from the statements and averments made in this petition, it is noticed that the encroachment is by encroachment of the lands, which purportedly belong to the family of the petitioner, is by private persons. So it is alleged that such encroachment is by mafias, land mafias. First of in view of the aforesaid projection, the direction sought by the petitioner in the instant petition filed under 226 of the Constitution of India to the respondent authorities to make the aforesaid land of the petition encroachment free is not found to be maintainable. Post of the petitioner, if the encroachment is by encroachment of the said plots of land, which are projected to have belonged to the petitioner, by private individuals, including land mafias, the petitioner has to seek recourse to the provisions, seek recourse, seek recourse under appropriate court of law as permissible, appropriate forum as permissible under the law.
Right. 14. Item 14.
So I have already served the copy. He's here.
Yes. What do you say about this?
I'm taking the telephony instruction. As per my telephony instruction, department is not aware of this organization. This one supplied care foundation because they have not obtained any NOC from the department.
But the impugn notice is filed by the district social welfare officer.
Yes, but that is filed by the district social welfare officer. And as per my telephony instructions, he has obtained the permission from the concerned district commissioner for issuing this notice also.
Whatever a public authority has issued a notice, and from the notice itself, it appears that he has directed direct closure
Yes, Lordship.
without any show cause notice.
That is true.
That appears to be not in conformity with the principles of natural justice and fair play. And the reason is that proprietor has criminal activities. If that particular establishment or whatever de-addiction center, there is criminal activity, okay. But his involvement in criminal activity is separate from criminal activity carried out in the de-addiction center.
Regarding that de-addiction center, Social Justice and Empowerment Department has no information because this center has opened of their own. They have not taken any NOC from the Social Justice and Empowerment Department.
But how?
And this district social welfare officer, she is not under our jurisdiction. She is under Women Child.
Oh, okay. That yes, 14 page 47, Mr. Haldar. This is a different department. Have you made them party?
The rehab center.
Have you made them party?
Let's see, I have a SOP, Lordship.
No, you have a SOP. Whatever.
Operating.
No, come to page 47.
47.
What does it say? Office letterhead?
District Social Office of the District Social Welfare Officer, Department of Women and Child Development.
He is not the.
I have made them as a party as respondent number 3, Lordship, who issued the impugn notice, and the SOP which says, Lordship, the Department of Social Justice and Empowerment is the main authority who supervise the running of the rehab center, Lordship. I have the SOP, Lordship. There is a district legal committee, Lordship, represented by the.
I had Mr. B. Haldar, and counsel for the petitioner. Mr. R.M. Das, learned Standing Council, Social Justice and Empowerment Department, Government of Assam, for the respondent number 1 and 2. And in any Standing Council for Women and Child Development? No. Then Mr. Rasket?
3 and 4.
Mr. N. Das, learned Junior Government Advocate, for the respondent number 3 and 4. Full stop. Para. The petitioner has stated that he is a joint managing trustee of One Love Life Roman and Care Foundation, which is a registered public charitable trust, with its principal office at Choukham, Gaon,
Registration couple of.
Dhemaji.
রেজিস্ট্রেশন অথরিটি আছে তো প্রভিশনাল সার্টিফিকেটও আছে
The trust
ডাইরেক্টর অফ হেলথ
stroke foundation runs a drug de-addiction center from the said place. If it is trust, how can there be a proprietor?
managing trustee and the joint managing trustee and trustee. They mentioned it a proprietor lordship.
Huh?
In the impugn notice, the authority mentioned the managing trustee as proprietor lordship.
I think, my lord, the registering provincial registration, it is issued for 1 year. 16/10/24,
Page
26, my lord.
Page
6.
26. Then it is under health and family welfare.
Yes. It says, my lord, provincial and only for 1 year.
The petitioner, sorry, what can I say? The foundation. Everything is jumbled up.
Medical council registration,
Huh?
page 40.
Because for opening a draft rehabilitation center, they has to open a registration from social
Ah.
justice and employment. No registration, nothing, no anything from social justice and employment. That is why something.
The foundation, owned by, everything is different, owned now. Owned by one Simanto Borua, things are not falling into places, Mr. Haldar.
So I have mentioned.
Was granted provisional registration as a clinical establishment under section 15 of the clinical establishments within bracket registration and regulation bracket close Act, 2010 for providing medical services as a rehabilitation center under allopathy system of medicine. And as per the certificate of provisional registration granted by the issuing authority on 16/10/2024, the certificate was valid for a period of 1 year from the date of issue. Its issue. Post office. Para. The person, Simanto Borua, came to be arrested in connection with a criminal case registered as Lahwal Police Station case number 21/2026, registered for the offences under section 305 small a, 331 within bracket 3, 324 within bracket 2, Bharatiya Nyaya Sanhita for alleged commission of theft of a car.
Some stolen property has been found in his car.
Full stop. For alleged commission, nalage ar ki ase ki na jano. The after arrest, Simanto Borua is in judicial custody since 9/6/2026. First up. In the above backdrop, comma, the respondent number 3 has issued the impugned notice for permanent closure of the de-addiction center run under the aegis of AEGIS, Love Life and Care Foundation. Full stop. In the notice, comma, it is mentioned that pursuant to A1, compliance report received from Messrs. Upper Assam Drug Rehabilitation Center Association against the de-addiction center, comma, it is found that the proprietor, within bracket Simanto Borua, has links to criminal activities and has pending court cases. Post op. Further mentioning about non-compliance as regards involving inmates, the response number 3 by the impugned notice directed permanent closure of the de-addiction center with immediate effect from 22/6/2026. Full stop. Para, the ground of challenge no, the order dated 12/6/2000, impugned order dated 12/6/2026 is challenged on the ground that the response number 3, before issuing the order for permanent closure, did not provide any prior and reasonable opportunity of being heard to the foundation stroke de-addiction center of Love Life and Care Foundation, and the impugned order is therefore in clear violation of the principles of natural justice. Post of the matter of required consideration, issue notice, returnable on so and so. Paragraph. The learned counsel for the respondents have submitted that the petitioner, without impleading the Women and Child Development Department, Government of Assam, under which the response number 3 is an authority, comma, has preferred the instant writ petition, and therefore the writ petition is liable to be dismissed.
One more, my lord. Since it is
May kindly peruse page 16. They have
Page?
stated 16. They have stated that this is a trust. And the number of trustees are also mentioned in column 4. Who is the trustee? One is the managing trustee and another is a joint managing trustee. Page 16, number 4, serial number 4, number of trustees. And in page 26, that is annexure 4, so-and-so located at so-and-so colony owned by Sri so-and-so, only one.
The counsel for the respondents have submitted that there are a number of anomalies in the writ petition. First of, it is further contended that the de-addiction center has no registration under
Social justice and empowerment. Has not
social,
obtained any.
under the Social Justice and Empowerment Department, Government of Assam,
Lordship.
which is the nodal department to run a de-addiction center.
Lordship.
Also, the matter would require consideration. Issue notice.
Registration has already been
Expired.
expired, way back in 24.
As per OPC registration, first registration for the period of 3 years.
3rd August.
As Mr. So and so has appeared. No formal notice, extra copies. The point of maintainability is kept open for consideration. And as raised by the learned counsel for the respondents, is kept open for consideration on the returnable date or at an appropriate stage. First of para on a perusal of the impugned order dated 12/6/2026, it privacy appears that no prior notice was issued to the petitioner asking was issued to the foundation stroke de-addiction center asking it to show cause as to why the de-addiction center should not be closed, meaning thereby, privacy, there is violation of the principles of natural justice. So as the impugned order has been issued directing permanent closure of the de-addiction center, and it is asserted that as on date, there are inmates in the de-addiction center, it is ordered in the interim that the impugned order is so and so shall remain suspended till the return. Inmates are there. He may be punished, but inmates should not be punished.
Highly obliged.
These are drug addicts. Sometimes it happens in the de-addiction center, they become more addict.
Yes, Lordship.
Instances are there.
Yes, yes. Because we are not aware of this. Yeah. Start reduction.
Time being item number 16. Third August.
At the end, let me finish. Let me try, otherwise, some other day.
For admission, item number
Where,
26.
Mr. Misro, where revocations are filed?
In our online portal, man.
Which one? No. Which item? Out of
Item
these?
number 16 and 17, revocation are there.
And 18 is normal.
Oh, no.
No revocation.
No, it was not allowed, my lord. It was not allowed because time period was elapsed, my lord.
Let us see 18. Let us see which one.
Stopwatch at page 14, my lord. Order is at page 15.
Did you furnish return up to?
And I have furnished return, my lord.
Up to August.
Up to August is allowed by the portal, my lord. I have furnished portal.
But here also revocation.
It was not allowed, press 25 minutes.
Because expiry of time. Okay, this will be disposed of. Let me find, if I get time, I'll find out about 16 and 17. Yes, admission.
For admission, item number 26.
Wait, please, Your Lordship. Senior is having some health issues, Your Lordship. Kindly adjourn the matter for the day.
Okay, on the request of
S. Sharma.
as Sharma Learned Counsel. The case is passed over for the Case stands adjourned for a week. Miss P. Bharosaiji, you are for? Learned count for the respond number 4. Okay. Miss M. Mormon, 1. Are present. N. Goswami. Let's apply our mind before
Lordship,
vacation.
may kindly fix a date.
Let it be.
Action number 28.
May I please, your lordship. This application I is to bring on record some subsequent events, my lord. When the writ petition is pending, my lord, the CGST department, they have issued notices of notices. And after that, the petitioner have also sent emails in the reply and all this. And after
No,
that,
original repetition is for what? Original repetition is for what?
it is DRC 01.
Challenging what?
Original writ petitions.
Uh-huh.
There was some pending.
What?
Back.
From GST
Yes,
74.
yes.
Section 74.
And,
Yes.
and as per the. order,
And what is the order there? Interim order. What kind of interim order?
Page number 15.
Would have been deducted that requisite taxes. By the petitioner cannot make any coercive action. The friends interim order. Then interim order continued.
And after that, the petitioner applicant have paid the taxes by DRC 03, that is annexure B, pays from 19 onwards, page number 19 onwards, my lord. By DRC 03, he have made the payments for the tax period 2019-20, 2021-22, as well as 18-19 for the tax period. But my lord, after that, during the pendency of the writ petition, the civil department have issued notices, and after that, when he have appeared also, and 12, finally on 12 to 2026, they have passed the adjudication order, my lord. It is Annexure C, page 25 of the IA, my lord. Page 25, my lord.
So what is this? What was challenged here in the writ petition?
If in the writ petition, my lord, the tax period is same, my lord. That he have.
No, what was challenged in the writ petition? First, tell me.
It was like, my lord, he had participated in the tender process and was awarded different works under the PWD also. The applicant is, he is a registered dealer under the service tax, my lord. And he.
What relief you sought there? So impugn notices 11/3/2022, 1/4/2022, and unblock the payments of the petitioner and all proceeding action pursuant to 11/3. 11/3.
No.
11/3. Which one is 11/3?
Lordship, page 48. And exact 3.
48, my lord.
Asking you to explain.
Lordship.
This is one.
Yes, my lord.
Then what happened? Next one is page 55.
Hmm.
In this regard, payable by you under seeking with reference to safety sustained by the so and so. Whatever is given below, you have advised to pay. Okay. Pay, failing which show cause notice.
Yes, my lord.
Failing which show cause notice. Okay.
My lord, then he have paid the.
What kind of interim order you were enjoying?
My lord.
In the writ petition?
Writ petition. Only that after that time, my lord, 5/8/2022, and the requisite taxes have already been deducted as shows by the respondents in the PWD from the bills of the petitioner.
No. What kind of interim order
No,
you were enjoying?
There is no specific, no coercive measures to be taken.
Since the court by order dated so and so, at passing in the case will also be applicable to the state respondents.
Shall not be any coercive action.
The submission of the so we get their willingness and the pay. Okay, the directive to take instruction on the submission made on behalf of the petitioner regarding their readiness and willingness to pay
Yes, my lord, we have already paid.
dues if properly calculated. Yes, you pay
Yes, my lord, we have
Ah.
paid 82 lakhs.
82 lakhs.
It is in, means, annexure B pays from 19 onwards of I. Here DRC 03, by DRC 03, we have paid. And I have,
Why is I? What is the reason?
I is to bring on record the subsequent events during the writ petition, pendency of the writ petition, my lord. The adjudication order has been passed, my lord, on 12 to
Which is
2023.
the adjudication order? Which one is the
Page
adjudication?
25, Lordship.
Page 25 of I.
25.
Lordship.
Now it is being challenged.
Yes, my lord, yes. my
Now
lord.
it is being
Yes,
challenged.
my
Yes, Mr.
Lordship, no show cause notice has not been annexed in the IA, Lordship. Only the order has been annexed. Lordship, in page number 25, there is a reference. In page 26, there is a reference of show cause notice dated 23/9/25. That is not being annexed in the IA, Lordship.
Where it is mentioned, so called notice?
Lordship, page 26.
Page 26, which paragraph?
Lordship may see the column.
Oh, that
show cause notice.
23/9.
23/9/25.
Now, what is the ground of challenge in this I?
This I, my lord, this is the pendency to writ petition. They have passed the application. Apart from giving email.
Pendency, what kind of interim order you are enjoying? That is what I am asking.
No coercive measures was given, even that.
Huh?
And my lord, one more thing, kindly come to page number, regarding the tax period, my lord, I'm saying table 32, page number 32 of the IA, my lord. The table, here a table has been shown. It is regarding 2019-20, 2021, 22, 23, 23, 24. And our writ petition that was in filing 2022, it was regarding 1899, 1920, my lord. So that time we are enjoying that no coercive measures. And again, they have calculated the same tax, including the 2019-20, 2021 till 2024, my lord. That's why I filed this IA that during the pendency of the writ petition, this adjudication order has been passed, my lord. They have calculated the same tax period, my lord. As shown in table 3, 32 page number 32 of the IA, my lord. And they have demanded a short pay of 1 crore 36, it is 96,000, my lord.
I have not understood. Initially, when the writ petition was filed, it was at the stage of section 74, subsection 5. With the contemplation that there might be a notice under subsection 1 of section 74. Right? And this impugn order appears to have mentioned a show cause notice, perhaps under section 74. Is it not? Dated 23/9/2025. Page 26. This might be under section 74. Let us see the last part of the impugn order. 74. 9. That page 49. So this order is why bad? Because initially all this DRC so and so, thereafter 74/5 notice.
Yes, ma'am.
Right. And thereafter followed by 74/1 notice. Right. Thereafter 74/9 order. Right. Why it is bad?
My lord, they have calculated the same financial year here also. That we have already paid 82 lakhs for that financial year, 89.
That after a notice is issued, right?
Yes, ma'am.
If you have paid, it is like after something offense is committed, the word sorry, that will not wipe out the offense. Likewise, if something penalty, whatever, we'll see, but tell me the main ground on which this is challenged. That you have paid them amount, still it is included.
Yes, yes.
It
my
is
lord.
your case.
Yes, my
Where
lord.
is the statement?
Lordship, at page 37, the column written submission and personal hearings. Lordship, they were given the opportunity of personal hearing. Lordship.
Doctor.
Page 37, para 2.0, Lordship, written submission and personal hearing. Lordship, may I read, Lordship? Skip it.
Where have you stated that you paid before the adjudicating authority, proper officer?
Para 3, my lord. Of my-
Para 3
Para 3 of my.
of the
Page number
IA.
9. Yes,
IA.
yes, my lord. Page number 9.
Has it been taken care of in the
No, no, my lord.
order in original?
It was not.
No, Lord.
No, no, my lord. No. And the election is.
But your liability is running into crore.
Lordship.
You have paid only 10 lakh peanuts.
No, and 62 lakhs also, it's
Huh?
62 lakhs for the tax period 2021 also, my lord. 10 lakhs for 1920, 10 lakhs for 1819 and 62 lakhs for 2021, my lord.
Para 3 says about 1 year, 2 year,
3.
3 year. 30 lakh. Okay, 82 lakh.
Yes, my
82
lord.
lakhs.
82 lakh.
82 lakhs.
Lordship, but they have not intimated to the department that they have
Right.
paid, Lordship. Because Lordship may, it is apparent from para 2.0 at page 37. They have not filed any reply, Lordship. One advocate appeared, but they have not filed any reply. They took time of 15 days. However, no submission has been made by the taxpayer till date,
Where
Lordship.
is that annexer B, madam?
Page 19, Lordship.
Page 9. Here the DRC.
Find out 82 lakhs paid.
Lordship.
I had Miss N. Gogoi, learned counsel for the applicant read petitioner. Mr. A. Jain, learned counsel on behalf of Mr. S. C. Kyle, senior counsel. And special counsel CGST for the opposite party number
2 and 3, Lordship.
opposite party the suspend number 2 and 3. Mr. H. Borua, learned counsel on behalf of Mr. G. Gogoi, learned additional advocate general Assam, and standing counsel, government, finance and taxation department, government of Assam for the opposite party number 4, 5, 6, and 7. Postal. The petitioner as the the applicant as the petitioner has assailed in the accompanying with petition WPC number 4367/2022 has assailed has entirely assailed a notice dated 1/4/2022 issued under Section 74 within bracket 5 of the CGST Act, demanding to deposit a sum of rupees 73,53,362.64 by 30/04/2022, failing which show cause notice would be issued under Section 74 within bracket 1 CGST Act. Full stop. Whereas it is the case of the applicant writ petitioner that during the pendency of the writ petition, the petitioner, applicant petitioner, had deposited a sum of rupees 82 lakh for the tax periods, FY tax periods 2018-2019, 2019-2020, and 2020-2021. Full stop. The notice under Section 74(5), but that is for a different period.
Lordship.
Was for the tax period 2020-2021. Full stop. As despite such payment, an order in original under Section 74(9) has been passed on 12/2/2026 after a so-called notice issued under Section 74(1) on 23/9/2025. Full stop. It is the contention of the learned counsel for the applicant petitioner that the impugned order in original did not take into consideration the payment already made by the applicant petitioner and a demand for rupees 1,36,96,200 has been made for the tax period of from 2019-2022, 2023-2022. The matter required consideration. Let notice be issued as so appeared, no formal notice. I expect a copy of the application within 2 working days, having regard to the projection made from it is observed in the ending that there shall not be any coercive action against the applicant petition in terms of the impugned order in original dated so and so till the return. The respondents, the original order to leak petitioner, and the respondents, the opposite parties, the respondents shall file their counter affidavits within 4 weeks' time. Release the returnable date, no? On or before the returnable date.
7th August. Items 30 and 31.
Yes.
Affidavit has not been filed.
Affidavit is ready. I couldn't serve him, so.
In which case?
My lord,
Both the
it-
cases.
Yes, yes, my lord, in,
You can look at your.
in 6128, my lord.
Where it is not filed?
Affidavit has not been filed with us.
Who?
By the-
Which respondent?
No, no, my lord,
Which department?
my lord, the forest department.
Forest department. You belong to forest department. You have filed
He has
in both the
filed-
cases.
Not both the cases, my lord,
Huh?
in one case is there.
The PCC 108.
My lord, kindly see the last order, my lord.
My lord, what has happened, these petitioners, after having failed, having failed here to get interim orders, some of them have gone for PI also. We are dealing all these cases one by one, my lord.
Right. At this stage, we are not dealing to the merits. And now he is saying that the forest department has filed an affidavit in 1080.
Yes.
Do you intend to file any affidavit in 6128?
Question of class. Well, we'll file it because these issues has to be addressed. But
Heard
my lord-
Mr. A. Bhorasaji, learned counsel for the petitioners in both the petitions, Mr. D. Gogoi, learned standing counsel forest department.
My lords, perhaps did not be required because the governments cover the issue.
Forest department. And who else, Mr.
Lordship, I am for respondent number 7. Private respondent.
Private response.
IDAS.
C. Sharma.
C. Sharma, learned counsel for the private respondent. Anybody else? Miss M. Borman, learned junior government advocate, Assam,
Oh,
and
right.
Miss N. Bordwell, learned standing counsel revenue department. What are respondents going to do? Official response. C. Sharma for the private respondent for you. Mr. Gogoi, learned standing counsel forest department, has submitted that in view of the counter affidavit filed in WPC number 1080/2026. Another counter affidavit in WPC number 6128/2025 is not necessary, as the counter affidavit filed in WPC number 1080/2026 should address the issues in the other petition also.
My lords.
Right?
My lords.
None.
Exactly.
Anybody else? You want to file affidavit?
Yes, Lordship, in 1080.
Okay, Mr. Sharma, learned counsel for the private respondent has sought for and is granted. How much time?
It is ready, I'll file it by tomorrow.
Okay, 3 weeks time to file an affidavit, counter affidavit on behalf of the seed respondent. Leaves the case on so and so. The interim order somewhere? No.
No intent.
We'll file the reply, my lord.
File it. Who has prevented you?
0508, 5th August. Item 33.
The bank has filed affidavit today, Lordship. And as per affidavit, the amount has been credited to the account of the petitioner, Lordship.
Credited?
Yes, my lord. We have credited as a service gesture, not as a fault of the bank, my lord, because he is a esteemed customer. And my lord, it is freeze till now because of his own protection. If your lordship directs us to defreeze it, then we can defreeze it, the matter may be disposed of. We have credited the amount.
Heard Mr. S. Alom, learned counsel for the petitioner, Mr. H. Sharma, learned additional senior government advocate for the respondent number 1, 2, and 3, and Mr. M. Smith, learned counsel for the respondent number 4. Post up. Para. 27 to 2026, sir. Second para. Para number 2. You are Cholamandalam.
No, XDFC.
Okay. Para 3. It was Para 3. As the case to transfer to Rupoihat police station for further investigation, comma, the learned government advocate was asked to obtain instruction regarding the progress of investigation in connection with Rupoihat police station case
We have received these.
I returned to you earlier. So that is why it is done.
4-5 lines.
Rupoihat police station case number 174
Yes, 174
to 2026 under section 318 within bracket 4 and section 319 within bracket 2, comma Bharatiya Nyay Sanhita. Full stop.
Last 5 lines. The concerned bank
On Mr. Sharma, learned additional senior government advocate, Kumar Sam, has submitted on instruction, comma, that the investigation of the case is still in progress. And statement of the petitioner recorded has been recorded along with other witnesses. Full stop. Along with statement of the petitioner, informant, and concerned bank officials have been recorded along with others under section. Concerned branch manager, Noga branch HDFC Bank, and others have been recorded under section 180 B Bharatiya Nyay Nagoric Code, even equal code count 2005. As per the affidavit filed by the respondent bank, respondent number 4, comma, the bank had para 4, I think, para 4.
No, para 4 and 8 will be relevant now.
The bank had acknowledged the complaint received from the petitioner regarding purported unauthorized transactions bearing acknowledgement number 2040-725-000-82-8423. The bank on 4/8/2025 had temporarily credited within brackets Sedo reversal the disputed amount of rupees 7,03,738 in the petitioner's account and the account of the petitioner was marked as no debit on 25/5/2020.
25/7, Malad, that's
25/7/2025 for safeguarding his interest. The temporary credit was done as per the Reserve Bank of India circular dated 14/12/2017.
Annexure 1.
On the subject, page 33, consumer protection has limited liability of customers in cooperative banks. This is cooperative bank.
No, private bank, but we have to follow all this.
Okay. In unauthorized electronic banking transactions.
Any fraudulent transfer.
It is stated that after receiving the complaint, the bank had done a detailed investigation and it was found that the LA's disputed transaction of rupees 7,03,738 was validly executed using the petitioner's net banking password and other sensitive information, which was supposedly known only to the petitioner, followed by second factor authentication, that is one-time password, which was always sent to the registered mobile number of the petitioner as the customer and his email ID. By such projection, the bank has stated that there was no deficiency and stroke negligence on the part of the respondent bank, and accordingly, the said amount was remitted on 8/9/2025. Para. Which one?
My lord,
Next.
Next para 8, my lord. 6 and 8.
7 and 8.
6, 7 and 8, my lord.
Last person.
In spite of the.
Don't tell me which one is. Where you have stated?
My lord, in para 8, my lord. Howard Respondent Bank. Para 8, my lord. On the last one, however, my lord, it's a lawsuit body, my lord. Howard Respondent Bank had credited the entire disputed amount in the account of the petitioner 117.6 as service gesture and in accordance with the RBI circular.
Who is responsible 2 and 3?
State.
Bank.
State.
Police.
My lord.
Yes. SP Naga and OC, we have persisted.
It is further mentioned that the account of the petitioner was marked no debit due to pendency of the cyber crime complaint and for safeguarding the interests of the petitioner. However, the bank has no objection to deactivate the no debit option of the account of the petitioner as the bank has already credited the entire disputed amount in the account of the petitioner on 17/6/2026 as a service gesture and in accordance with the RBI circular. It is further stated that the alleged fraudulent transaction is being investigated by the investigating authority, So is there any process for recovery?
My lord? No.
Any recovery is involved?
No, my lord.
the respondent bank authorities would provide due assistance in the investigation. First of para. So no loss to the bank if the amount is,
But they already transferred, Malad.
I don't know.
One that I don't know, but this,
Huh?
as a service gesture, the bank
No,
has.
I don't no, see, Mr. There is a consequence.
Malad.
Suppose as a service gesture, you are making him
Malad.
that amount.
Malad.
But in the process, you have lost something.
Maybe, Malad.
Whether that instruction is available or not.
Not, I am not available.
Huh?
I have asked, that's why they have just transferred the amount.
So no loss to the bank.
But that I cannot say, Malad.
So tell me, otherwise that if the recruit.
Adjusted the earnings from the bank.
That I don't know.
Loss.
Apparently, so there should be something. You are saying that service loss, service lesser, you should have said something. As insofar as the grievance raised by the petitioner as regards the sum of rupees 7 lakh, 7 lakh,
3,738.
and the other grievance regarding debit fees of the accounts of his savings bank account or loan account. Savings bank account maintained at so branch of respondents so are concerned. The said grievance have been the first of the said grievance has been mitigated. Full stop. As regards the second grievance is concerned, the respondent bank shall take necessary steps to allow the petitioner to operate his bank account.
Within a period of 1 week, Malad.
Within a period of 1 week from today, full stop. If in the process of crediting the sum of rupees 7 lakh so and so by the respondent bank in the account of the petitioner, any loss has been suffered, and in the course of investigation, any amount is recovered, the investigating authority shall duly take into consideration such loss suffered by the, if any, suffered by the petitioner. If any, suffered by the petitioner. Right.
The instructions may be kept as a part of
The instruction placed by Mr. Sharma, Additional Senior Government Advocate, in the form of office letter number so and so are to be kept with the case record by marking them as document A.
Malad.
This order disposes of the petition.
Only that part, that loss if suffered, Malad, by the respondent bank, Malad.
A respondent. If any suffered.
34.
From next time you get the instruction regarding any loss.
Item 34.
Here, my lord, sale permission has not given to the petition in spite of it is a patta land, my lord. It was mutated.
Instruction received.
affidavit filed, my lord. They have filed their affidavit in reply today, my lord.
Okay, let it be after vacation.
That may be. So,
Hired Mr. H. Das, Learned Counsel for the petitioner, and Mr. N. Das, Learned Junior Government Advocate, Assam, for all the respondents.
3-4, my lord.
3-4. Anybody else? Okay, aforesaid, Standing Counsel Revenue 1 and 2. The Learned Counsel for the parties have submitted that exchange of pleading is complete. Release the case on so-and-so.
2206.
7. 07.
2206.
07.
Hearing.
Item 35.
Bank account again.
Yes.
Bank account.
Your lordship observed to.
Yes, any affidavit.
I have filed my affidavit on last occasion. Nodal officer were supposed to bring on.
But how much regarding suspicious transaction? complaints are received. To what extent?
20,422.
Total?
That was the total. I have annexed the copy, Your Honor. That
Tell
is,
me.
Page 26.
You read page 26 and tell
Yes,
me.
2,250 rupees is disputed, reported from Bihar on and another
It's 27.
disputed rupees 5,000, which was put on hold, and another rupees 15,422.
Page?
Page 30.
You have filed your affidavit?
Yes. They have newly implemented a nodal officer as a respondent authority.
So, action was hearing to place on the record, my lord.
Over page 20? Have you made any statement? Have you made any statement in the affidavit?
Regarding the amount, we have not stated
You should have said so.
Yes, disputed amount we have mentioned in page 22, that is rupees 40,000 and rupees 3 lakhs respectively. Page 22.
This is not regarding his account.
His account.
His account, this is total disputed amount regarding the complaint lodged by.
How much benefit he had allegedly received in his bank account?
That is in page 26, 2,250.
You could have, why you're taking me to all those? You could have made the statement.
Yes,
You were taking me all to all these figures and to try to find out from there.
To tell you.
Why you could not make a statement, specific statement?
That I could make.
You are taking me to these figures.
20,400.
It should not have been done like that. So casually, it should not have been filed.
Yes,
You expect the court to go through all these figures, 100 figures to find out which are the.
No, only 3 amounts are there, Your Honor. That I could have mentioned.
You could have mentioned it for the court benefit.
Yes, yes.
You do not take the trouble.
Yes, I apologize
for making the statement. You throw everything to the court as if the court is a dustbin.
No, I apologize for that.
You should not have done that.
Yes.
At least you should have made the effort that 3 lakh is the total amount involved in the cyber crime. And out of that, an amount has been received, credited in the bank account of the petitioner to the extent of 20,000, 30,000. You could have said that.
Yes.
The official one of directed open instruction. With regard to my lord, sum whether there is any other amount that is still awaited, my lord. I'll take one more opportunity.
My account has been, my lord.
I know, but it is otherwise, see, issue of territorial jurisdiction is there. But we are going carefully on that.
By keeping the disputed amount on Lian, my lord.
That is, I've been passing that order, Mr. Ali, but taking all the procedure compliance. Right. So, make a statement, Mr. Soikia.
Yes.
Exact statement.
Yes.
How much suspected transaction amount had been credited to the account of the petition? That's all.
Yes.
Make a specific statement. You are the bank.
Yes.
Because you have kept the entire account on hold. How much is the credit? Total amount in his
Total
bank?
amount would be, Your Honor, 20,422.83.
No, in his bank account.
Yes, Your Honor. In his bank account, 20,422.83 would be the amount. 2 transactions were in his account.
No, what the question I am asking? Are you not following me?
I might get it wrong here.
In your affidavit, have you stated where from this cyber complaint had originated?
Yes, Your Honor.
Where have you stated?
In para 9, Your Honor, page 21. That the
Tell
account-
me in a piece of paper, what are the suspicious amounts? In a piece of paper. Write down now. I'll put it in your statement. Since there is nothing in the affidavit.
But in the annexer, I have mentioned.
So, have you not understood?
Yes, I got it. I got
Are you
it.
not following me?
Yes, I got it. Yeah.
Heard Mr. R. Ali, learned counsel for the petitioner, comma, Mr. U. Shoikia, learned counsel for the respondent number 1, 2, and 3, and Mr. N. Das, learned junior government advocate, Assam for the respondent number 5. Post. Para. Affidavit is very casually filed, Mr. Shoikia.
Decided prohibition.
The petitioner has preferred the present writ petition and the Article 226 of the Constitution. No, like in this writ petition, the petitioner has stated that he is a student. Student is not a profession. You are a student as well as businessman. Difficult double role. Petitioner has been maintaining a savings bank account number 64040150792 at Dhubri branch of the respondent Bank of Baroda. Post of. Since 1/7/2024. Post of. Para. In the present, the petitioner has heard that when he came to, when he visited the branch or sorry, what branch? Key branch? Dhubri branch. In August 2025. The respondent number 3 inform him that his bank account, the petitioner's bank account, had been freezed on the basis of complaints received from on the basis of cyber complaints received from Vaishali, Hajipur, Bihar, and Sorapur Police Station, Karnataka. The petition was informed that the bank account was frozen due to, had been freezed due to two fraudulent transactions amounting to what? Everything is 20. Two fraudulent transactions. Everybody is so casual.
Paragraph 4, 5,000 and 15,000, 20,000.
Mr. Soikiel and counsel appearing for the respondent bank has submitted, on instruction, there are altogether how much?
20,400.
How many suspicious transactions?
3 suspect.
3 suspicious transactions involving amounts of rupees
2,200.
That is rupees, how much in total?
Total would be 20.
You have not done that homework also. Good.
22,670.83 rupees.
In total. He has further submitted that at the time of keeping the bank account on hold, his total amount in the account is more than 22,000?
That is not here, yeah.
He has further submitted that the debit fees instruction had to be made in view of the instructions received. That complaints were registered in connection with the said 3 suspicious transactions in the National Cybercrime Reporting Portal, NCRP, from Cyber Police Station, Boisali, Hajipur, Bihar, and Sorapur Police Station, Karnataka. Full stop. He has submitted further that apart from the instructions received with regard to the said transactions amounting to rupees 20,000 something, no other instructions has been received till date by the respondent bank. Full stop. Where was that? Right. There are 7 allowed to operate, keeping that much amount on hold. Okay. Mr. Mishra, sorry, we cannot take up today. We'll see. We'll issue notice otherwise. We don't know. Provided time permits for your case. Release the case on the Wednesday. Sorry. Tomorrow also, no? Did you have tomorrow?
Tomorrow.
35, sorry, 16 and 17.
16, 17,
18 is disposal. 18 is disposal.
18 disposed.
18 disposal.
Lordship.
18 is disposal.
Lordship.
Yes, Mr. Das.
36, 36, 37, my lord. Is admission matter, my lord. Hearing back.
Yes.
Non-payment of this acquisition, competition, my lord.
Okay.
My lord.
When you after vacation? Not possible in these days. I'll not also take up admission matters.
45, 46.
Let him deal with.
Let it be the after vacation, my lord.
Okay, NC Das, senior counsel for the petitioner. So who is for the respondent? Miss R. Bora, Alliance Standing Counsel, NHI DCL, A. Bhotasaiji, Revenue, M. N. Das, Junior Government Advocate. At present, list sought for and agreed to by the learned counsel for the parties, list the case on DDO immediately after vacation, same 37.
2007. Same period, item number 44, my lord. Bank, regarding bank account fees.
What to do after vacation?
After vacation, my lord.
Okay. HR Amit, who is for the bank? Who is to appear?
Name
Who
not
is to appear?
Name not shown in the custody.
While you don't know also the name.
42. There, my lord. Now,
Don't look at that side, that
he was
side.
there, my lord. But now, no.
AM Sharma for the respondent bank. Lays the case on so and so.
2007.
The name of Mr. AM Sharma, learned counsel for the respondent Ujjivan Small Finance Bank, is to be reflected in the respondent side in the cause list.
Obliged.
Yes, Mr. Soikia.
Just not be about date, my lord, with the on 22nd, my lord. Sure.
Okay.
22nd. 36, 37.
45, 46. Can you fix a date?
45, 46.
Okay. I thought that what are the service reports? But because of paucity of time, because there is a meeting, otherwise I would have said it. Would have said through the list. 45, 46. I Soikia. I did what data.
22nd July, 2207.
Lordship, item number 47, due to, this is the bank freeze case, due to the financial hardship that the petitioner is going through, I request for a shorter date, your Lordship.
Item number?
47.
Okay. You are for the petitioner.
I'm for the petitioner, your Lordship.
Okay, you are there. Okay, same. Okay. On the request of learned counsel for the petitioner, list the case on so and so.
1307. Reopening date.
Anything? Mr. Rajuri, you are waiting for some item?
Let it be after vacation.
Okay.
Government to file affidavit.
Government file, you have to file.
Yes.
Who is there? Mr. Das. They are required to file affidavit. Okay, Mr. P.K. Raichuri, learned senior counsel, is stated by Mr. A.K. Azad, learned counsel for the petitioner, are present. Mr. N. Das, learned junior government advocate Assam, appearing for the state respondent, has sought for and is granted 3 weeks time to file the counter affidavit on behalf of the state respondents, list the cases on so and so.
3rd August, 0308.
Yes, anybody?